In view of the aforesaid discussion, this court is of the opinion that a case for interference is made out accordingly the impugned order passed by the Registrar of Cooperative Society is set aside. Elected board of directors be accordingly allowed to discharge their duties in completion till the completion of the term, subject to following the rules and regulations. Records we are handing over.
Correct.
Records we are handing over.
And may I please, sir? I
Yes.
wish to mention for listing motion matter Miller,
When?
Friday. Okay.
May I please,
Yes.
Lordship? In item number 31, Lordship,
Yes.
we already filed one rejoinder affidavit, Lordship.
Yes.
That rejoinder affidavit is not there in the record, Lordship.
You want
That
to
may
bring
be-
it?
That may be called for, Lordship.
Yes. Give a requisition.
Much obliged.
Yes. Yes, Mr.
I
Pathak.
pray for listing of a matter for admission on first, my lord.
Admission, why? Out of
My
turn?
lord, this is a matter pertaining to sealing operations of 1972. It's pending.
Matter of which year?
Matter of 24, but then not listed since January, sorry, my lord, December 2024.
December 2024.
They are all
You
senior
make an
citizens.
application to the registry.
My lord, we have given several applications, my lord. These are all senior citizens now. Since 70s, my lord, the matter
But
is.
you
my
came
lord.
to the court in 24. We cannot
I
go back
understand.
to 1970. You
But
opted
then
to come and
the original cause of action is of 70.
maybe, but when did you come to the court?
In
That is what is
24.
of concern for
In-
us.
In
Okay,
24.
on first,
My lord,
on first.
first, my
Mm.
lord. Keep it.
Yes, Mr. Butler.
May please, your lordship, with the consent of the other side, I beg to mention item number 28, lordship.
2 yes.
The matter will pass over for the day, lordship.
On a request made on behalf of the petitioner, matter is adjourned to be listed after a week.
So there is an interim order, lordship.
Matter is adjourned to be listed. We give a date if there's an interim order.
Lordship.
To be listed on today's 27th, on 3rd September.
3rd September.
Interim order passed earlier to continue till the next date of listing.
Lordship, can it be on 5th, lordship?
Okay, 5th September,
Oblige, your lordship.
5, interim order, huh?
Lordship.
Yes.
Maybe, I beg to mention for listing of a one petition. Can be day after tomorrow, Lordship.
Motion,
No, it is for orders only, and it is matter maybe in settlement only. The matter has been fixed for orders, Lordship.
what is
And
the
it-
urgency?
There is an amount here which has been paid by the petitioner to the states, Lordship.
No, what is the urgency to get the matter out of turn listing?
Lordship.
Mention memo is an out of turn listing. Urgency has to be there. Sorry, next,
May please, lordship. My lord, matter pertaining to registration of marriage, lordship.
yes.
My lord, the government has filed affidavit, lordship. Matter was supposed to listed after 3 weeks, lordship.
What is the urgency in registration of marriage?
Marriage
Sorry.
is pending within the
Yes,
parties, lordship.
sorry, yes.
May it pleases, my lord, I pray for listing of two writ petitions, my lord.
For
Urgency, my lord.
motion,
Motion, my lord.
motion, yes, motion,
Friday, my lord.
yes.
I'm very grateful, my lord.
May I please, Lordship? Lordship, with the consent of the others, Lordship, I beg to mention item number 57, Lordship, supplementary cost list, Lordship.
57,
Yeah, Lordship,
Yes.
for adjournment, Lordship.
motion matter.
Motion matter,
57 is connected, 58, 59.
Lordship.
Last time also you have adjourned these matters.
Lordship, yes, today my senior, he's supposed to do Lordship, but he's at.
We
Lordship.
said that your senior can appear online.
Lordship, he's
We
having,
cannot adjourn matters like this. Have you seen the order sheet?
Lordship, yes.
How many times this has been adjourned?
Lordship, he's having personal.
Motion is not adjourned unless there's a difficulty or great difficulty on the part of the council. It's your urgency.
Lordship.
Last time it got adjourned. Cannot adjourn motion. Yes, when do you want? Give a date. No further adjournment.
Lordship, after 10, any date, Lordship.
Have you informed the council for the other side?
I have been informed, Lordship.
Okay. A request for adjournment has been made on behalf of whom?
As Burgoyne, Lordship.
As Borgo Hellenic Council for the petitioner in WPC in one of the writ petitions. Para. On request, list on,
After 10, any date, Lordship.
list after 2 weeks.
2 weeks, Lordship.
Yes,
Humbly obliged, Lordship.
Well, item, 48, my lord.
yes.
IA file, my lord, here, my lord.
IA4,
IA for, my lord, deletion of one sentence, my lord. The order, my lord, it was my mistake, my lord.
yes.
Actually, my lord, my learned friend is also here, my lord. Just to delete the line, my lord, it was.
So what do you want?
Lordship, item 48,
What do you want now?
my lord, this line may be deleted, my lord. Because it was my submission.
No, let the matter be taken
Yes,
up.
yes, my lord.
Why do you make a mention of a matter?
Yes, sorry, man.
Make time for listing of petition for admission next week any date, Lordship.
Admission, why urgency?
So what happened here, my lord, case credit account of petitioner was freezed, my lord. Case credit account of petitioner was freezed. That was removed by the order of this honorable court. However, some amount was deducted, my lord. Now she is seeking the refund because it was illegally deducted, my lord.
Yes,
May I
Sorry.
plead your lordship,
My lord.
with the consent of the other side, I beg to mention item 45 of today's list. Your
yes.
lordship, we have received an affidavit in opposition yesterday only, your lordship. We have to obtain instructions,
You're for the petitioner.
lordship.
Okay, who's for the other side?
I have obtained consent, your lordship.
Affidavit has been filed by whom?
18 and 32 by the respondent 18.
Two of the private respondents.
Lordship.
Okay. On the request of Miss F. Hussain, learned counsel for the petitioners, matter is adjourned by 2 weeks to enable her to obtain instructions on the affidavit in opposition filed in the meantime by respondent numbers
18
18
and 32.
and 32.
Lordship. Deeply
Is
obliged.
there an interim order?
No, lordship. Obliged, your lordship.
Yes.
Lordship, with the
Yes.
consent of the respondents, Lordship, I beg to mention item 35, Lordship. Can
Yes.
it kindly be taken up on the day after tomorrow as some similar matters are fixed on that?
Okay. Sri S.D. learned counsel for the petitioners has informed that similar matters are slated to be listed on Friday.
29th, Lordship.
Friday.
Yes.
Friday. One of them, one of those being WPC
The 2328 of 2025.
2328 of 2025. Para. Let this matter be accordingly adjourned and listed along with
Lordship.
so and so on Friday.
There's an interim order.
Interim order passed or later continue till the next date of listing.
Much obliged.
My lord, I beg to appear online, my lord.
Yes.
But
yes.
last time I am before your lordship, my lord.
Yes, yes.
My lord, I have, my lord, already, my lord, handed over my lord, the copy of the judgments to the junior of Mr. Koyal. Your lordship has directed Mr. Koyal because there are two admitted facts.
Where is Mr. Kyle? You are there.
Yes.
Yes. What are the judgments?
My lord, the admitted facts are that, my lord, the no pre-decisional hearing was given before blocking of the electronic credit ledger. My lord, in our portal, it has to be uploaded. It has uploaded that till 24th June 2025. Your
Yes, has it been settled by a Supreme Court judgment?
yes, my lord.
Is the issue?
I don't have that. Kyle
And-
is there, your lordship. He is.
Where is Mr. Kyle? Where is Mr. Jain? Last time, if you remember, Mr. Ghosh, you are Mr. Ghosh?
Yes, yes, my
He
lord.
has submitted that this issue is resolved by the Honorable Supreme Court.
But in a K9 judgment, K9 is a my lord, now my lord, the well orchestrated judgment of the my lord, the Telangana High Court. Then my lord, it went up onto the my lord, the Supreme Court. Supreme Court my lord affirmed the K9 judgment, my lord.
State of Karnataka versus K9.
Lordship, actually, our name has not been reflected in the court.
Telangana.
Okay, Friday we'll have. Friday, Mr. Ghosh? For
Yes,
motion.
my lord.
Okay.
Lord,
Lordship, not on Friday, on Monday, Lordship. Then.
Why?
Friday is.
My lord, we are suffering day by day. Our business has
Okay,
been struck,
Monday.
my lord.
Mr. Ghosh, Monday will finish it off. Okay. Heard Sri D. Ghosh, learned counsel for the petitioner who has appeared online. Full stop. He has renewed his submission that the issue involved has already been resolved by the Honorable Supreme Court in the case of State of Karnataka versus K-9 Enterprises, which was decided on 16/5/2025.
I'm grateful to your lordship.
Sri K. Jain, learned counsel, has however submitted that he is led by his senior Sri S.C. Kyle, Senior Standing Counsel, CGST,
Lord.
whose name has, however, not been reflected in the cause list. Para. He has accordingly paid for some accommodation. Para. Considering the above, the matter is adjourned and as requested, fixed on Monday,
Lordship.
on first, Mr. Ghosh will finish
Yes, my
it.
lord. I hope, my lord, they will come with an instruction. my
Yes,
lord.
yes.
I hope, my lord.
The name of Mr. Cal may be reflected in
The name of Sri S.C. Kal, Senior Standing Counsel, CGST, be reflected in the cause list. Do you have a copy of this judgment? Madam, please give
My lord,
the
my-
reference, she can take it out.
Okay, fine.
Much obliged, Lordship.
Okay.
With
Okay,
instruction.
next.
I am grateful.
Mr. Sharma?
On the last occasion, Lordship, the counsel for the income tax department.
Yes, Mr. Chitin.
Lordship, we have received instruction, Lordship. In
Yes.
fact, my lord, that reply was considered, my lord. It was taken into account, my lord, while
Okay.
passing the assessing order.
Yes,
Not the, my lord, everything, my lord, is about the factual disputes, my lord, whether the amount was deposited by the.
then we issue notice.
Lordship, on the page number 57, Lordship, when the assessment order was passed, it is Lordship, notice under subsection 1 of section 142. That was reflected that Lordship, that was not taken into consider that it is received.
We'll issue
Yes,
notice,
Lordship.
we'll examine your contentions.
In the meantime, Lordship, that assessment order that might be assessed because penalty that will impose continuously otherwise. Lordship.
What do you say on this?
My lord, otherwise, Lordship, the appellate provision, my lord, appellate authority is there, my lord, and in fact, my lord, nothing on.
He has not preferred any appeal.
He has not preferred, my lord.
Lordship, only the circumstances that to
In fact,
prefer an
my lord-
appeal, Lordship, the section 4 of section 249 is need to be satisfied by the Lordship petitioner, Lordship. In that case,
Pre-deposit.
My lord, that can be waived, my lord. There is a provision, my lord.
You can file an application for waiver.
Otherwise, my
there
lord,
is no specific provision to file with that is the only.
You file an application for waiver. If it is not considered, you can come before us. There's a specialized authority, appellate authority will go into all facts. Now, unless you make out an exceptional case
Yes.
for invoking or 226, you may not get the appropriate relief. Your primary contention was that your reply was not considered.
Yes, that is
Now-
not considered.
Mr. Chetia has got the instruction that your
And-
reply has been considered.
in fact, my lord, that was
If that
reflected.
goes, the other will be strictly on merits. How much we can enter into the merits is a question.
But Lordship, from the document itself, it reflected that it has not been considered. The question of consideration will not come unless and until it is received, Lordship. Because this is the assessment order that has been passed by the
Third,
income tax
Sri D.
department.
Sharma, Deva Sharma, learned counsel for the petitioner, who is aggrieved by what is the date of the order?
My lord, 1/3/2025.
By an order dated 1/3/2025, whereby a demand has been made under section 156.
My lord, this is the assessment order, my lord, and demand has been raised subsequently. He has challenged this one also, Lord.
Okay. And a demand has been made under section 156
Lordship.
of the Income Tax Act. Full stop. It is contended that the reply of the petitioner was not even considered when this matter had come up for consideration on 8/8/2025. This court had directed Sri S. Chetia, learned senior standing counsel, Income Tax Department, to obtain instructions. Sri Chetia, the learned standing counsel, has submitted on instructions that the reply was in fact considered. Full stop. He has also pointed out that there is a provision of appeal in which the petitioner can raise his grievance. Let notice be issued, returnable by 4 weeks. Sri Chetia, the learned standing counsel, accepts notice on behalf of all the respondents.
My lord, 2/4, Lord.
One,
One Union of India.
okay, Union of India, anyone? CGC, madam? Ms. K. Fukan, huh, 1, and S. Chetia, K. Fukan, CDC, S. Chetia, 2 to 4, standing consultations, extra copies. What are you apprehending, Mr. Sharma?
Lordship, from the notice issued under section one, subsection 1 of section
What is your
142.
apprehension regarding the interim period?
Lordship, apprehension is that, Lordship, if I will not pay the Lordship demand notice as per the demand notice, then Lordship,
Sri
subsequent
Sharma,
penalty
the
that will
learned-
be imposed,
Sri
Lordship.
Sharma, the learned counsel, praised for an interim order. After hearing, it is provided that till the returnable date, no coercive action be taken against the petitioner pursuant to the demand notice dated 1/3/2025. The aspect of maintainability of the writ petition is however kept open.
Lordship, my submission to the effect that I oppose interim.
Yes, interim order, Sri Chetia has, however, strenuously opposed the interim prayer and has renewed that the matter can be agitated before the appellate authority.
And factual disputes are involved. That
And further, that the disputes involved are factual in nature.
not. Deeply applied.
Hello, please.
Yes, Mr. Hawk.
My lord, the last occasion, my lord, the lordship has directed me to obtain the extraction as per under which section, my lord, the land was acquired, my lord. It was under the provision of Assam Land Requisition and Acquisition Act, my lord, 1964. Section 3, my lord. In fact, my lord, although it was their incumbency, my lord, to mention the provision under which the land was acquired.
In the 64 Act, is there any provision for seeking enhancement?
Fair compensation is there, my lord.
Huh?
Compensation is there, my lord.
No. Is there any provision for seeking a reference? So 1968 Act.
My lord, whatever in this case, my lord, what is market price is, my lord, 1 crore 30 lakhs, my lord. But the district commissioner has granted this solar team at the rate of 45 lakhs, my lord. That is far less, my lord.
No, that is what your assertion, but is there any dispute resolution forum?
I think provision is there.
Mr. Hendrik? Huh?
I have to approach before the Malad that district judge.
Under which provision?
Provision. Malad, in fact, Malad, the petitioner has raised their grievance, Malad, before the DC, Malad.
Mr. Hawk, you are not neither. I don't think you have even understood the question.
Malad.
Is there any provision for making a reference to the adjudicating authority in the lines of either section 18 of the old act or section 64 of the new act? That is the precise reason we have asked you under what provision of law this acquisition has been made. You haven't got the act of 1964. If you don't come prepared, how can we help you, Mr. Hawk? You come to section 12 of the act.
Yes, the reference to court, Malad. The collectors can, in every case, within them, that's a native.
There is a provision for making a reference under section 12.
Malad. Refer to court.
The ideal course is to make an application before the collector, make a reference under 12,
My lord,
get it adjudicated.
my lord.
How can a writ court deal with a matter of claim for enhancement?
Lordships,
Yes.
Rule 19, Lordship.
Hmm?
Rule 19 of 1964.
Rule 19 of which rules?
1964.
Rules or act?
It is rule of. Act. Recovery of money payable to government.
The Henrik, you have also not come prepared.
Lord,
You come to section 12 of the act. Which book are you carrying? Let us see the book. Is it the same book? Mr. Henrik, is this the book?
Lordship.
Some other book? Come to the 1964 Act,
64 Act, Lordship.
section 12.
Compensation on 11, Lordship.
12. Reference to court.
Refers to court, Lordship.
Please read.
Lordship, where any person aggrieved by an award made under subsection 3 of the section 11 make an application required to the matter referred to the court, or where there is any disagreement with regard to the compensations payable under subsection 4 of section 11 of the application, the person entitled to compensation requiring the matter to be referred to court, refer the matter to the decision of the court.
When court has been defined in section 2B, 2B, definition. Court. Same definition.
Lord.
Principal Civil Court of Original Jurisdiction. 2B.
What are any differences?
Yes, what do you do, Mr. Hawk?
My lord.
We close this, you give liberty.
Well.
But is there any time limit?
Yeah, there is 30 days probably.
How do you overcome that? And see subsection 2 of 12(2), subject to the provisions of this act, the provisions of the Land Acquisition Act of 1894 shall mutatis mutandis apply, then the provision of law limitation will come in. When was the award published?
It was published, my lord. Thank you. On 8/10/2024, my lord.
8/8.
8/10, my lord.
8/10.
Right.
It's already over. It is on 1864 or 18th or 1894 land acquisition originating. More than 6 months have already
Right.
elapsed. Now, if the provisions of 1894 will apply.
My lord, the compensation amount has not yet been released. That compensation amount, my lord. that is
From
not
the
yet
date of
released.
publication of the award.
Yes.
Let us see the award. Which page?
25, my lord.
Page
It's
20,
25, my lord.
25.
Yes, my lord. Yeah, my lord, the rate of land per biga was column 8, my lord. Was calculated as 45 lakhs per biga.
You take instructions on this aspect. Section 12.
My lord.
Okay. Hartsbury S. Hawk Learned Counsel for the petitioner, who in terms of the order dated 18/8/2025 has obtained instructions and has submitted that the acquisition has been made in terms of the Assam land within bracket requisition and acquisition bracket close Act 1964. Full stop. The said act, however, contains a provision for referring to the court in case of any grievance which the award. Full stop. At this stage, Sri Hawk, the learned counsel, prays for some time to obtain instructions in this regard. Para, list for motion on Monday next.
My lord. Obliged, my lord.
May it be lordship. Matter relates to my lord cancellation of registration. In fact, matter is squarely covered by your lordship decision, your lordship.
Yes,
My lord, our instructions are still awaited, my lord.
you have a look at this.
I have given
Yes,
copy.
given me a copy, my lord.
It's covered last time, the matter 18/8, we had given you time.
My lord.
I have made necessary corrections also.
My lord, if it is covered, then my lord may please to dispose it of my lord.
We'll record his name, huh? Have you gone through this corrected copies?
My lord, yes, quickly, my lord.
Just go through again, then we'll make the corrections. B. Chaudhary is otherwise there in the court. You appear for Gogoi or Chaudhary?
D Gogoi, my lord.
He's there in the court or not?
My lord.
B. Gogoi. Okay.
Fine.
Yes,
Obliged, my lord.
B. Chaudhary, B. Gogoi.
Instructions were sought from.
Item number 5.
Instruction not received, my lord, will seek our more time, lordship.
He's only seeking for a reference under 64
Lord,
of
my
the
lord, that
Fair Compensation Act of
Reference
19.
has also been done. Only the thing is that in terms of section 65, certain documents were to be submitted by the DC. That has not been done. Only that thing.
that's why, my lord, he
Oh.
seeking more.
On the prayer of three. No. When this matter was taken up for consideration on 28/20/25, the United States Council was directed to obtain instructions as the grievance was with regard to a reference under section 64 of the So-and-so Act 2013. लिख दीजिए. Para. The J. Hendrick Learned State Council prays for some more time to enable him to obtain the instructions. Para. List after 1 week. We'll have it on Wednesday next for motion.
Much.
Item 6.
May please, Lordship.
Lordship, this application is claiming Lordship limited guardianship, Lordship. So here I have Lordship only limited player, Lordship. Very recently, Lordship, in one similar case, Lordship, this court examined the issue, Lordship, and passed a direction, Lordship. If that much is given, Lordship, my problem will be solved, Lordship.
I'm for one only, lord. I'm for one.
What do you say? Heard Sri H. Talukder, Learned Counsel for the petitioner, who by means of this application is praying for a direction for appointment as limited guardian to his brother who is said to be suffering from schizophrenia, so as to assist him for drawing the arrear salary and invalid pension which have already been granted. Para, let notice be issued returnable by but you are challenging an order of the court.
No, Lordship, actually, no, Lordship. This court has already stated, Lordship, clarified that this court has no jurisdiction to direct the authority to for limited guardianship, Lordship. But some observations were made and some directions were made to the petitioner as well as to the.
How do you challenge an order of the court in a writ proceeding?
No, Lordship, no court proceeding, Lordship. Lordship, no order, Lordship. I have not challenged any order, Lordship. The fact is that, Lordship, I applied for limited guardianship, Lordship. That was rejected.
That is returnable by 4 weeks. Miss R. Devi, run it CVC 1 and state J. Hendrick 2,
2, 6, 7 and
2, 6, 7 and 8. Elementary education,
Lordship, B.
B. Deka,
Respondent 3, 4 and 5.
3, 4 and 5.
Minus 4, respondent number 9, I'm getting one instruction.
Okay, what is your name?
Arthon.
R. Chauhan. 4, 9. And what about 8? 8 has been 8.
Yes, Lordship, I.
Okay, extra copies. But that aspect might come, that order of this court is there. Okay.
I have not challenged the court's order, Lordship. I challenged one order passed by the National Trust Board, Lordship.
There's a caveat.
Very correct.
Ms. Sinha, you are the caveator.
Yes, ma'am.
Third, 3 case Sinha, learned counsel for the caveator who has lost this caveat qua an order dated 22/7/2025 passed by the mayor in council within bracket appeal, Guwahati Municipal Corporation. Full stop. The caveator will be heard in the event this court proposes to pass any interim order. Caveat stands discharged. Yes, Mr. Khatane.
This petition is directed against an order. The interim order relates to sealing of my business premises. Sealing of my business premises.
Sealing, okay.
Yes, sealing of my business premises. Allegedly on the ground of not having a plate license.
Yes.
Whereas you also will find that I have a valid license which is valid up to 31st March 2026.
Where is it?
It is valid up to.
Where is it?
It is in
Where is the license?
License, yes. Also will find that page 65. And extra 10. I also got it. Subject to provisions of GMC Act and rules bylaws made thereunder, the license is hereby granted to so and so Rahmat Ali, that is the petitioner, others, manager from company.
If this was there before the authority, if this was
Yes.
there, then why was the sealing order?
I don't know, because Lordship will kindly see, there are two provisions. One is section 378. Initially, notice was issued to me under section 378. 3, Lordship will kindly see the provision. That provision is meant for revocation or suspension of license. That notice was issued by the commissioner.
Okay.
And that matter was pending before the commissioner.
Okay.
And while that matter was pending before commissioner, there was no decision pending, there was no decision given. The respondent file, who had some civil dispute with me, he filed an appeal. He filed an appeal without an order of this commission. You can see how the appeal is maintainable. Section 378. 3. Initial notice lordship will find at page 69. That notice was issued under section 378.
Which act are you?
GMC.
Act.
Yes. First, I will take a lordship to the notice issued by the commissioner under section 378, page 69. That's
69.
69.
Yes.
Notice under 378, 3 of GMC Act. They issued to Dhanani Schools, the petitioners. Now, lordship will kindly see the third paragraph.
Yes.
Thus, under the power conferred under the provisions of GMC Act 1971, you are hereby directed to submit the below listed documents within 7 days of receipt of this notice, telling which action shall be taken against you as per provision of the GMC Act 1971 and the concerned bylaws of the GMC Amendment Act 2021. So there's documents are listed, that's it. And one document that is valid trade license. We have produced it before the commissioner. It was pending, no decision was given because I had a valid license. Their allegation was that I had a fake license, trade license.
Okay.
That fake trade license that was referred to in the impugn order, that does not belong to me. That is some other trade license.
Where is the appellate provision?
Now, lordship will come to section 438.
438.
438. Means there is no order, no appeal license. 438. I think it will be at page 171.
Yes, we have it.
Yes.
Appeals from
Appeal from
commissioner.
Commissioner, Mayor and Council. Notwithstanding anything contained in the provisions of this act in the matter of appeal, an appeal shall lie to the standing committee from any notice issued or other action taken or proposed to be taken by the commissioner under any section of this act, under any bylaw concerning house drainage or the connection of house drains with municipal drains or house connections with municipal water or lighting mains. Any refusal by the commissioner to grant permission to construct or reconstruct the building.
Yes, we have read this.
Yes. So there must be some order or refusal or whatever. And even for granting or not granting, the also will find at 1D. There are also an appeal lies if any order is passed by the commissioner.
Yes.
So when there was no order passed by the commissioner, the respondent filed. He filed an appeal before the
What is your response to A? 438 A. Any notice issued?
Yes. No. Notice issued by the commissioner. Order must be passed.
No. See,
I have not filed the appeal. They have filed. The other side. He does not have any look on because this dispute is between me and the municipality. The private respondent, my lord, who has some litigation pending with me, he owes
the
me.
notice of 30/12/2024 issued by the commissioner under 378(3) is on the basis of a complaint lodged by him. Now, if as per 438A, an appeal may also lie against the notice. What is your, if you go by the plain meaning, what is your
No.
response to this?
That notice was issued to me. I could have filed the appeal, not him. That is my subject. How he can file? He is a private respondent. He doesn't have anything to say. Because this is as regards the issuance of.
This is your case, Prime Officer, this is your case.
And you will find that license is valid till 31st.
Okay. Yes, Mr.
Absolutely, there is
Sinha.
no application of mine.
Sinha?
My lord,
See, examination of this matter, we'll do it on the interim prayer.
my lord, in that case, my lord, I have an objection, my lord, because the respondent of 5 hearing, my lord, is the owner of the whole property, my lord. Now he was my tenant.
No, that part we cannot take into
Definitely,
consideration
my
today.
lord, yes, I have lodged the complaint saying that, my lord, he is
Now,
occupying.
how does the appellate authority assume jurisdiction?
So, my lord, on the basis of my complaint, I have submitted.
Okay, this notice was issued by the commissioner.
Yes, my lord.
Matter is before him.
Yes.
Before, when the proceeding was pending before him, how does the appellate authority assume jurisdiction? The impugned order is not passed by the commissioner.
My lord,
It is passed by the mayor in council, is the appellate authority.
mayor in council.
So how does the appellate authority assume jurisdiction? You can find it out in the commissioner's proceeding.
No, my lord,
Your complaint can
this
be
order is
decided
passed
in
by
your
the
favor.
mayor in council, my lord.
Proceeding
what
for
capacity?
that proceeding is still pending.
In what capacity? In the capacity of an appellate authority. Well, how does the appellate authority assume jurisdiction? These are the conditions.
Yes, ma'am.
No order is passed. That is why we have just tried to extract from Mr. Khataniar
My lord.
that this also contemplates a notice. This obviously cannot mean the notice can be challenged by the person who has put the complaint. It can be challenged only by the person who is against whom the complaint is made. He is not aggrieved.
No,
He
no,
is
my
not
lord,
the
I am not
applicant.
challenging the notice.
How did you file the appeal?
Appeal, no, I am not filing an appeal. My lord, I have filed a complaint.
Before the
On,
commissioner?
yes, on the
No,
basis
so
of let me finish. My lord, on the basis of my complaint, the commissioner issue notice.
Yes, thereafter?
On that notice, certain documents are called for,
Yes.
and that document was not satisfied by the authority because my lord, kindly see the
Which
my lord,
authority?
my lord, by the commissioner.
Then where is the order of the commissioner?
Yes, that order is not there. My lord, kindly see
If
the
the order
notice.
is not there, appellate authority cannot
My-
just jump in.
That is my lord, that is
That is what we are examining.
my lord, my lord, my lord. My
We
lord,
only
my
examine the
only concern,
decision-making
my lord,
process.
my only concern.
Decision may be his side, decision may be your
My-
side. We are only on the decision-making process.
Yes, my lord, that part is there, my lord. My lord, my only concern is, my lord.
Okay,
Well-
we'll balance it.
My lord.
Heard, Sri P.K. Khataniar, learned counsel for the petitioner.
My lord, only one part, my lord. He could not produce the my lord land document, my lord, because there was no agreement between us. I am the land
We
owner.
get this matter adjudicated by
My lord,
the
my lord.
commissioner.
My lord.
Learned counsel for the petitioner who is aggrieved by an order dated 22/7/2025 passed by the whom?
The respondent of who? Mayor in council.
By the mayor in council as the appellate authority, whereby the sealing of the office premises situated at TRP Road, Fancy Bazar, Guwahati has been ordered. Full stop. It is the case of the petitioner that he is running the business by having all the requisite, by fulfilling all the requisite qualifications and also has a valid trade license. Full stop. However, on a complaint lodged by the respondent number 5,
my lord.
5, a proceeding was initiated under section 378 of the Guwahati Municipal Corporation Act 1971 and notice was issued by the commissioner. Full stop. However, during the notice was issued by the commissioner on 30/12/2024. Full stop. However, before completion of the proceeding, the respondent number 4, who is the appellate authority, has passed the impugned order.
No, there is another notice subsequently after the impugned order was passed. Again, commissioner issued notice again. Another notice.
Okay. The learned counsel has submitted that the respondent, that the mayor in council can assume jurisdiction only upon fulfillment of the conditions in section 438 of the Act.
Yes,
438 appeal.
yes.
But you have not made the mayor in council a party, you have made him by name. Why?
Because name is mentioned there, I can delete it.
No. If you
Because-
make a name,
Because
if tomorrow somebody else come here, it goes.
I can delete.
Now, you should have made the council a party, then you can, if you have nullified it, you can make also the,
Yes, the affiliation is there.
but tomorrow if this person goes, then what will happen?
Is there lawsuit?
Now, you should, I think you should better amend this cost title.
Yes.
Because we respond number 4, we cannot even say him to be the appellate authority. He is a person by name.
Yes.
Password কি করুন? Full stop, para. Let notice be issued, returnable by 4 weeks. 3. Guwahati Development Department, Mr. Bora. 1, 2. 1, 2 is as Bora. 4 is by name. 4, it has to go by registered post with AD. 5 is there.
5 is there.
3, Sina, learned counsel, except who is on caveat, accepts notice on behalf of restaurant number 5, extra copies. 4, registered post with AD, steps within 2 working days. Para. 3, Khatani, the learned counsel, praise for an interim order. Full stop. He has submitted that the mayor and council, who is the appellate authority, can assume jurisdiction under section 438 of the Act only when an order is passed by the commissioner for suspension or revocation of a license. And the proceeding before the commissioner is still pending. Full stop. Para. 3, Sina, the learned counsel for the caveat, has however strenuously opposed the interim prayer and has submitted that there are other violations made by the petitioner and the order has been rightly issued. Para. After considering the rival submission, this court is of the prima facie opinion that the mayor and council as the appellate authority can assume jurisdiction only on fulfillment of the conditions in section 438 of the Act. Full stop. It is not in dispute that the proceeding before the commissioner, which was initiated vide the notice dated 30/12/2024, is still pending. In view of the above, till the returnable date, the impugned order dated so and so shall remain suspended. Para. Pendency of this case shall not be a bar for the commissioner to pass appropriate orders on the proceedings initiated under section 378 of the Act.
It is already put on
My lord,
seal, man. Already seal.
Okay. Taragot Kuba. As a consequence of this order, the respondent authorities should immediately remove the seal so that the petitioner can run his business.
Yes.
But commissioner can proceed.
my lord.
If we think,
My lord, that,
we have said already.
that observation, my
We
lord.
have said,
Because my lord.
we have already said.
My lord.
Yes.
Yes.
My lord, respondent number 5 contested election on the false document, my. And
You are again a
we are-
voter.
Oh, yes, my.
Yes, we issue notice.
Look.
Maintainably point left open.
Look.
No, Mari se to bahut bada. Heard 3 HR Chaudhary, learned counsel for the petitioners who are aggrieved by the election of the respondent number 5
Yes, ma'am.
as a Gao Panchayat member from ward number 3 of Mahakal Gao Panchayat in the district of Sribhumi. It is submitted that the said respondent number 5 had submitted forged documents regarding her educational qualifications. And in this regard, the petitioners had filed representation before the district commissioner on 30/7/2025, which has not been acted upon. Para? Let notice be issued, returnable by 4 weeks. 3. Yes, who's
Number 3.
1? Thapa, on behalf of S. Dr. 1? Only 1. Election Commission R. Dubey, 2. 3?
I'm appearing.
3. And 4, President Mahakal, I think notice will have to go.
Yes, that's
4 and 5
4
will
and
step
5.
posted AD.
Okay.
Steps within 2 days. Extra copies will appear over. Well, the learned counsel for the respondents have, however, raised an issue of maintainability of the writ petition, as the petitioner was not a candidate, but only a voter. Where the aforesaid issue would be is kept open.
My lord, by this time, my lord, my representation will be disposed of.
Pendency shall not be a bar for consideration and disposal of the representation.
Annex the relevant of this. Annex the relevant of this.
Yes.
Obliged.
Mr. Zaman?
Lordship, the petitioner is removed from her elected post as Panchayat Board member, my lord.
Okay.
The removal is based on a complaint, my lord, filed by the private respondent number 10, who was also a contestant in the election, my lord. And the allegation is that the petitioner performed her marriage
marriage.
underage.
Child
my lord.
marriage.
Child marriage, yes. Now, my lord, this allegation is rested on the date of birth of the petitioner's daughter, my lord. As per the finding of the impugned order, my lord, petitioner's daughter.
Okay, we'll examine.
Yes, I have annexed the date certificate, birth certificate also.
3 MM Jaman. Learned counsel for the
I have
petitioner.
interim prayer, my lord.
Interim prayer is difficult. You have been removed, learned counsel for the petitioner who is aggrieved by an order dated 16/7/2025, whereby the district commissioner Gwalpara has removed her from the position of a Gao Panchayat member. Full stop. It is the case of the petitioner that she was elected as a member from ward number 8 under the Kalpani Chandamari Gao Panchayat in the district of Gwalpara. Full stop. However, the respondent number 10 had instituted a complaint that regarding on the aspect that the petitioner was involved in a child marriage, and based on the said complaint, the impugned order has been passed. The learned counsel submits that there was no basis in the complaint, and without taking into consideration the relevant aspects, the impugned order has been passed, which is not sustainable in law. Let notice be issued, returnable by 4 weeks, 6 weeks. For yes, Chief Secretary, yes, and was submit for 1.
For 5 lots.
1 also, Chief Secretary.
Lots 1 and 5.
1 and 5. Panchayat Thapa for S. Doctor. 2, 3. 2, 3, 6, 7, 8. 4. Election Commission R. Dubey. And 9. 9 also, I think.
My lord, this is MNRR Civil Hospital.
Superintendent Health, is there anyone from Health Department? H. Burwa.
9.
On behalf of B. Gogoi, Health Department 9. Extra copies 10 registered posted AD.
My lord.
Yes.
My lord, if possible, the impugned stay of the.
How can you? You have already been removed. We cannot restore you back on the first day.
To grant finally interim.
Obliged, madam. My lord, name of SC Health may be reflected in the cause list, my lord.
You will not have much of a role, but still then, name of SC Health may be reflected in the cause list.
Obliged.
With your lordship. Lordship, before I start, lordship, there are some mistakes cropped up in the writ petition, lordship. Annexure 6 was wrongly filed, lordship, annex. This is objection by the respondent, lordship. So may I pray to withdraw with liberty to refile, or your lordship will file an additional
We have
affidavit?
not seen such an effect of a caveat.
My lord,
Writ petition is itself being withdrawn.
my lord, if that is withdrawn, my lord, my caveat also goes. Then, my lord, I have to
Or
lodge a
lordship may direct,
fresh caveat.
lordship may allow me
We
to
have
file
seen
an
interim
additional.
order being refused. We have not seen writ petition being withdrawn.
The caveat goes discharged, my lord.
Will you have a caveat in withdrawal?
No, withdrawal, I don't have a caveat, but then, my lord, once it is withdrawn.
You might have a caveat for withdrawal also.
That annexure 6
because my
page
lord,
27
my-
can be brought on record by way of an additional affidavit also, lordship, if your lordship permits me.
It's up to you. I think filing will be better. Fresh filing will be better.
My lord, I also like to point out, my lord.
No, if she's
I
withdrawing,
serve copy, lordship.
if she's withdrawing, let her withdraw and file.
But then, my lord, let us serve a copy, my lord, so
Lordship,
that I
I'll
don't have to
serve.
lodge.
You have a wakalatnama, we'll hear you.
Lordship.
First, we discharge the caveat.
And my lord, if I may take a minute, my lord, then some of the pages are not really
So
legible.
this has been withdrawn, that is why. All these have been taken into consideration for withdrawal. Those she has not spelled
No,
out.
I am not objecting. my lord.
Heard Sri M.K. Chaudhary, London Senior Counsel, assisted by S. Count for the caveator who has lost this caveat qua a judgment dated 26/6/2025 passed by the Assam Board of Revenue in respect of case number. A caveat will be heard in the event this court proposes to pass any interim order. Caveat stands discharged. In the main writ petition, you write. Heard Miss R. Chaudhary, learned counsel for the petitioners. Also heard Sri. Also heard Miss G. Hazarika or Miss G. Hazarika, learned standing counsel revenue, comma, Sri N. Goswami, learned state counsel, and Sri M.K. Chaudhary, learned senior counsel, assisted by Sri S. Count for the respond number
6, 7, and 8.
6, 7, and 8 para. At the outset, Ms. Chaudhary, the learned counsel, has submitted that due to inadvertence, there are certain defects in the writ petition, and accordingly, she may be allowed to withdraw the same with her liberty to file afresh. Para? The said prayer is not objected to by the learned counsel for the respondents. Para? In view of the above, the writ petition is dismissed on withdrawal with liberty as paid for.
Lordship, I'm deeply obliged.
Yes, Mr. Goel.
My lord, matter relates to non-issuance of proposed notice, my lord. This matter is also covered, my lord.
Some time may be granted to obtain our instruction.
Okay, Friday.
Right.
Friday, okay. Heard Sri A. Goel, learned counsel for the petitioner who is aggrieved by
Order dated 28.
by a show cause,
No, my lord, order.
by an order dated
30/12/2020.
30/12/2023 issued by the respondent number 3 under section 73 of the Assam AGST Act 2017. Full stop. Amongst others, it has been contended that the said action was not preceded by a properly served show cause notice. He has also submitted that the issue is covered by earlier decisions of this court. Para. Sri H. Barua, learned counsel, appearing on instruction of Sri B. Gogoi, standing counsel, Finance Taxation Department, prays for little accommodation to have instructions in the matter on the issue as to whether it is covered by earlier decisions. Para. In view of the above, consideration of this matter is deferred till Friday. To facilitate Sri Barua to have the instructions, let an extra copy of the writ petition be served upon him during the course of the day.
Date may be mentioned, my lord.
Friday date, she'll give, day after tomorrow.
Oblige, my lord.
Yes, Lord, Ganguly.
Lord, this case, my lord, there is a warrant of arrest issued by the Bakijai officer. My lord, my limited grievance that, my lord, I go to the Bakijai office. I have also paid some token amount, my lord, earlier. My lord, I do not have a single, my lord, loan document or the copy of the certificate, nothing, my lord. Now, even the warrant of arrest was posted outside my house, my lord, and this is from a photograph taken. This petitioner, my lord, is an illiterate person. He admits that he has taken a loan. He's not shying away from that. But at least let him access to the loan document, the certificate, and whether the prescribed formalities have been complied with. That is the limited grievance.
In this case, Corporation Department is the main party. Their name has not been shown, Lordship. Only I am for the Commissioner of Police, sir. I have little role, Lord. Corporation Department.
Mr. Ganguly, since you have some urgency,
Lordship.
can you wait till tomorrow?
Lordship.
Tomorrow, but you've served
I'll
cooperation.
serve a copy to the standing council.
So cooperation is a party or not?
Yes, yes. Yes, yes. Corporation is party. Because the Bakijai officer is of the my lord, Corporation, Cooperative Society.
Yes, so who is the respondent number one? Mr. Ganguly, you also do this kind of mistakes.
No, this is.
What department?
Cooperation.
Huh?
Corporation.
Cooperation.
Corporation department. Fantastic.
Apologies. It should be cooperation. I have to correct that.
It's a new department called Corporation Department.
Because I think this is the result of.
You should take care.
Lordship, that
Not expected from you.
no, that I take full responsibility.
The subject matter involves the Cooperation Department. Courts of this court has however noticed that the name of SC Corporation is not reflected in the cause list. Sorry, Ganguly, the learned counsel for the petition undertakes to serve. Have you given a copy already? I think you have given.
Look, to the cooperation, I'm not sure, but I think we can only serve on the.
Undertakes to serve a copy to the learned standing council Cooperation Department during the course of the day. In view of the urgency expressed, list for motion tomorrow, date. 8 to 8 AM. Is that okay?
May it please the lordship. Well, it's a challenge to an order passed by appellate tribunal, my lord.
In how?
A NDPS, my lord. So, my lord, I think, my lord.
Why it's come before this?
Yes, my lord, division bench matter, my lord. As per, my lord, and Chandra Kumar's case, my lord.
No, even otherwise, why repetition in a criminal matter comes before this? Bench
No.
5 or what?
No, my lord, it's a division bench matter, my lord. My lord, what happened, my lord? The police issued a frozen certificate, frozen order, my lord.
Okay.
That-
Three and Dr. Learned counsel for the, sorry, NJ Dr. Learned counsel for the petitioner has informed that the subject matter involved in this writ petition has informed that considering the subject matter involved, this writ petition should be placed before the Honorable Division Bench. Raised to examine and list this matter before the appropriate bench.
I'm agree.
Right, please, sir, Lordship, here petitioner's husband died due to COVID-19. Lord, there was a scheme of the government in the name of Chief Minister to widow support scheme. Petitioner applied, but the same was not given. Thereafter, petitioner approached this honorable court and the honorable court issued a direction to verify in case of the petitioner have passed a speaking order. Thereafter, page 37, my lord, a speaking order was passed and she was found eligible. But the scheme amount, the one-time financial assistance is not. Page 37, my lord. Order dated 27/2025.
That representation is made on June 25th, Lordship.
No, the speaking order is on 27 to
February 2025, Lordship.
we issue notice.
Lordship.
Third, Shri N.R. Khandokar, learned counsel for the petitioner, who is aggrieved by non-receipt of the ex gratia amount of rupees 2.5 lakhs under the scheme of Chief Minister's COVID-19 Widow Support Scheme. It is submitted that pursuant to earlier directions passed by this court in WPC 3157 of 2023, the matter was examined, which had culminated in a speaking order dated 27/2/2025, whereby the petitioner was held to be eligible. Full stop. However, in spite of such determination, the amount has not been paid to her. Para, let notice be issued, returnable by 4 weeks. Revenue,
941.
Hazarika 1,
I got 2, 3, 4, and 6.
2, 3, 4, and 6. Health.
Lordship, I am for 5.
Okay. Upamanyu. The Upamanyu for 5. Okay. Extra copies.
Pendency, my lord, will-
Pendency shall not be a bar for release of the amount to the petitioner in accordance with law.
I am taking.
But GST cancellation, my lord, covered by lordship order, my lord.
Okay. Ravindra Vishwas, yes. Okay. Disposed of, huh? K. Jain and on instruction of SC Khan.
Deeply.
Give the order.
My lord, I'll provide, my lord.
Make the corrections, both of you. Both of you.
My lord.
Mr. Sharma?
Yes, my lord. Here, my lord, Kurwa SS Limited held so-called AGM, my lord, on 12/9/2025. And my lord, there, the January shareholders were only 153 or something. And total, my lord, presence was shown as 272. Quorum is 182, because total shareholders of the society is 1,820.
Your complaint has been rejected.
Rejected, my lord, and in thorough inquiry was made by the secretary as per direction, as well as ARCS. The lord also kindly find the inquiry report at page 30 to 45. And they found that there was no quorum and illegal members, non-members, non-shareholders were able to attend.
But you are only 3 of us. 3.
No, anyway, one shareholder.
No, that is okay. But how many of you did you file the lodge complaint?
Total there was 8 earlier.
How many members are there? Shareholders?
Shareholder 1,820. And
See,
inquiry is very.
Three of you are aggrieved by the chairman's conduct.
Yes. Yes.
What is the nature of the allegation?
Allegation the chairman, he included in the list and got it signed by Inspector Court Society, showing them to be shareholders. But out of 272 shareholders showed, 125 were non-shareholders. So quorum is required to be 182.
For RP Sharma.
And it's registered only did not go into all these things.
Assisted by Ms. Edeka. For the petitioners, full stop. The petitioners who are shareholders of the Kurua Samabai Samiti Limited had raised allegations against the chairman of the society in the AGM held on 12/9/2024. Full stop. Pursuant to the said allegation, an inquiry was also made whereby the ARCS had passed an order dated 7/2/2025 declining to approve the AGM. Full stop. The chairman, however, along with some members, had preferred an appeal, and the appeal was allowed by revoking the order dated 7/2/2025.
Yes.
Full stop.
Against that, we come to
The said order is also the subject matter of challenge in WPC 1587 of 2025.
Yes.
And the matter was remanded to the registrar
Yes.
for a fresh consideration. Full stop. After such remand, the impugned order has been passed on 2/8/2025, whereby the grievances of the petitioners have been rejected. Full stop. Para. Let's notice the issued returnable by 6 weeks. Are there any private respondents?
My lord.
Public society is there.
That chairman is not there by party, by name?
Chairman not there, my lord.
And-
Because he is the chairman of my public society.
Huh?
Allegation is against the chairman, he is
You
not.
should at least make him a party. He has to be given an opportunity.
Allegation is against him.
Yes, him and secretary.
And my lord, one aspect, in para 3, my
Yes.
lord, they say, my lord, the petitioners say that some of the aggrieved, my lord, shareholders approached.
Yes.
My lord, the petitioners do not say that they filed the complaint. They were not the complainant. And if your lordship sees the impugned order, they are also not the parties there. This is one of the fact.
My lord, one of the shareholders is
But
there.
you know, but those are matters Mr. Tandura will definitely raise. But what about the aspect of not making the chairman a party here?
That will implement it.
That I think you have to file an IS.
Exactly what they did, my lord, what, how.
Issue notice returnable by 6 weeks. 3, SK Talukdar Understanding Council Corporation Department accept notice on behalf of
1, 2, 3, 4, my lord.
1, 2, 3, and 4. That extra copies. The steps for service of notice upon the respondent 5 be taken by registered post to daily. Para. 3. Sharma, the learned senior counsel, raised for a liberty to file IE and plead the full stop. Liberty is granted.
The interim order may consider. My lord, after we correct it. Or
There is
interim
no
order.
question of any interim order.
My lord.
There is
Yes,
no
but
question
you
of
also
any.
will see. The register did not go to the aspect of the quorum
That
and
will
quorum.
amount into granting of the final relief.
My lord.
We cannot pass an interim order.
but-
First, you make the chairman a party. Let us see.
Yes, my lord, let it be 4 weeks, my lord, returnable.
There is a private respondent. How do you serve within 4 weeks?
Kurwa only, my lord.
No, you have to serve by registered post with AD.
Yes,
Even
yes.
if it doesn't come back, minimum 4 weeks. You take steps within 2-3 days. 4 weeks will be over. Okay, 4 weeks.
Yes.
Mr. Talukdar, there is one matter where your corporation is involved. Okay, we have tomorrow colony, Kali colony. Tomorrow will come up. Some Bakija officer issuing warrant of arrest, they want some temporary protection. They would otherwise appear. Mr. Ganguly is there, I think. A. Ganguly. Your name is not reflected in the call list. Because
Tomorrow it will be reflected.
yes, because the department is a new department, corporation department.
Oh, corporation. Obligation.
We had for the first time, corporation department.
Lordship, I beg to a virtually number 20.
Yes.
Lordship, this is a GST refund matter. It's a second round of litigation, Lordships. At page number 65, your Lordships will find the first order passed by this honorable court in 2021. Lordship, the issue was that I was exporting goods with payment of GST through a non-EDI port. Now,
Through a
Lordships, through a non-EDI port, which means which was not integrated with the ICE gate. So the refund processing, there was a board instruction that refund has to be processed manually. And the board had given a detailed process on how to process a refund. Lordship, GST law envisages an automatic refund.
What do you say?
Lordship, earlier they approached this honorable court, the order was passed. Lordship, a refund was processed. Thereafter, what happened, I don't know. I may Lordship, require. refund has not been processed. If it would have been processed, I would have not approached this honorable court again. Lordship, pleased to see.
No, we'll do one thing. We'll, if it hinges upon whether it's been processed or not processed, then the counsel is saying that it's not processed. Otherwise, he has a ground. Otherwise, he would not have approached this court.
Lordship,
We'll have this on Monday next. You get the instructions.
Wednesday.
Next Wednesday. What is your name, Mr. Counsel? We cannot get your name.
A. Kanodia, Lordships.
Mr. Kanodia, we can have it on Wednesday next.
Lordship,
Third, I have some difficulties because
Whenever you say you are online, we'll accommodate you.
Lordships, Friday, Lordships, if on 5th, if your Lordships is sitting,
Fifth is okay. Yes, fifth, okay.
grateful to Lordships.
Oh.
Much.
Third, Sri A. Kanodia, learned counsel for the petitioner who has appeared online. Full stop. Sri S.C. Kyle, learned senior standing counsel.
Matter related to custom rates.
Learned senior standing counsel customs
Lordship.
has, however, prayed for little accommodation to obtain the instructions on this matter. Para, as agreed to by the learned counsel for the parties, placed for motion on 5th of September 2025.
Lordship, stop up, you may kindly.
Yes, Madam,
Yes, Mr. Law.
to facilitate Sri Kayal to obtain the instructions, let an extra copy of the writ petition be served upon him during the course of the day.
Grateful to
Our colleague will go on to still serve.
Much obliged, Lordships.
Your Lordship, against the impugned notice dated 10/7/25, my lord, whereby the scope of the petition was sealed, my lord, only on the basis of a FIR lodged against him, my lord. Lordship, page,
FIR is regarding what?
my lord, regarding, my lord,
Selling of beef.
beef, my lord,
Selling of beef.
beef, my lord.
Beef.
My lord, the petitioner is having a license to sell raw meat as well as, my lord, buffalo meat, my lord. And on the basis of the FIR, my lord, the raw meat was seized
Okay,
from.
okay, regarding instrument, please a short notice.
Let notice.
Third, Sri J. Laskar, learned counsel for the petitioner who is aggrieved by the action of sealing the shop of the petitioner vide a notice dated 10/7/2025. Full stop. It has been submitted that on 1/7/2025, an FIR was lodged against the petitioner, which was registered as Algapur PS case number 38 of 2025. Full stop. The petitioner alleges gross violation of the principles of natural justice amongst other grounds. Let notice be issued, returnable by 4 weeks. Three, S.S. Roy, learned State Council accepts notice on behalf of all the respondents. Extra copies.
Can it be 3, my lord? It is
3
on
weeks.
4 weeks.
Okay, 3 weeks.
All right.
Please. So this matter pertains to cancellation of birth certificates of the petitioners. Your Lordship will
Cancellation
find
of?
birth certificates.
Cancel under what provisions?
Under the section 15 of the registration of births and deaths act. The communication whereby we are informed, your Lordship will find it at page number 32.
Cancellation is done by whom?
Registered birth and deaths.
Yes,
Lordship instruction. Lordship.
we'll issue notice. then.
Yes, Lordship, please.
Part 3, your Olaskar.
Yes, ma'am.
Part 3, Olaskar, learned counsel for the petitioners who are aggrieved by an order dated. What is the date of the order?
28/1/2022 and 4/6.
22 order.
Yes, ma'am. Yes, Lordship. So thereafter, we approved civil court, my lord, telling this order.
Then-
However, the civil court said that it doesn't have jurisdiction in view of section 28(1). That's why it was, your Lordship will find the order of the civil court at page.
Challenging order dated 22?
Yes, 22.
28/1/2000.
28/1/2022.
28/1/2022, whereby?
There is another, my lord, in respect of petition
And
number 2.
28/1/2022 and 24/6/2022,
Yes, ma'am.
whereby the birth certificates of the petitioners have been cancelled. Full stop. It is also submitted that the petitioners had initially filed the suit, which was, however, rejected on the ground of jurisdiction.
Yes, ma'am.
Para, that notice be issued, returnable by
reducing evidence would be there. Full stop. Para. In view of the above, this writ petition is dismissed by full stop. However, liberty is granted to the petitioner to approach the appropriate civil court for redressal of his grievance. Full stop. Dismissal of this writ petition shall not have any effect on the merits of the parties in the civil suit, if so filed. If so instituted. Yes, next. 21.
House and my premises, which was located in the Rengma Reserve Forest, which is annexed in annexure number H, page number 39 and 41.
Yes.
Your Lordship, after receiving the notice, I have approached to the Deputy Commissioner Golaghat on 24/7/2025 and requested him to give me reasonable time, as my father is a sick bed person and I have no other alternative, settlement option. So which I have annexed in annexure number J, page number 50 and 52.
Yes.
Your Lordship, on 28/7/2025, I have again prayed for time to relocate the resettlement to the Co-District Commissioner at the Sorupathar Co-District Office, which I have annexed as annexure number K.
Yes.
Your Lordship, on 29/7/2025, the Co-District Commissioner has called me to the office and they have given me a letter where he has referred a matter to the Deputy Commissioner.
No, your premises have been demolished by now.
Yes.
Now, what is your claim now in this writ petition?
Your Lordship, actually, I have no other, settlement option, and I have no, objection if government, evict me. But thing is that the government has not, considered my prayers. The commissioner has neglected my prayers, which is a.
No, ultimately, what do you seek in your writ petition?
Yeah, Your Lordship, compensation. I want the compensation.
Compensation.
Yes.
Compensation
relocation.
Under what law? You are an encroacher. You have been evicted.
Yes.
Compensation under what law? You have been granted notice.
Yes, sir.
Till how many years did you occupy the land?
Your Lordship, since 1976.
76, you were in government land.
Yes.
Now have been evicted and you want compensation. Under what is the basis? We have to understand first.
Yes.
What right of yours have been affected?
Your Lordship, we have no other option to.
No. See, that is a different matter. For that, can you seek compensation? First, we are on the issue of whether you can seek compensation. If you say that you are not an encroacher, you had Miadi Patta land evicted without following the due process. Yes. You said you wanted time was extended and ultimately it was demolished.
Yes.
Now for that compensation, you have to show some basis of praying for compensation.
And basically, I am approaching before Your Lordship for the violation of my fundamental right, because I was not hurt. I am a most deprived person because I am a transgender person. Somehow I managed.
No, you have to make out a case.
Yes.
Only by saying that you are transgender, you have to make out a case.
Yes.
What is the case which enables you to seek compensation for an eviction from unauthorized possession?
Yes.
And that too after notice. You have said a notice was issued to you.
Yes, Your Lordship.
On 21/7.
Yes, but only 7 days time was given.
You should have come before us. In appropriate cases, we have extended.
No, but
Now the demolition is done. Whether 7 days is adequate or not, that's a question we need to really explore. But question of compensation,
Your Lordship,
you have to show a basis. Mr. Saikia,
Yes, Lordship, there is no scope of compensation. Rather, he is little bit fortunate that till now no criminal prosecution has been initiated. It's a criminal offense to encroach a
what is
forest.
the kind of the status of the land?
These are all forest land, reserve.
Forest land.
Forest land.
Not khas land.
No, forest land. We are doing it only in the reserve forest areas. He himself is saying that the name of the reserve forest.
Yes,
he has
Rengma
stated.
Forest.
Rengma Forest. So they have committed two criminal offense under section 25 and 24.
Your Lordship, actually, the 15 days time was the direction of the Honorable Supreme Court, but we were given only 7 days, and we have been residing in that particular year since 1976, Your Lordship. The government.
What is your status? Are you a forest dweller?
No.
Are you belonging to the scheduled tribes?
No.
Had you been a forest dweller,
No, Your Lordship.
belonging to the scheduled tribes,
No.
then matter would have been different.
Yes.
If you are an encroacher,
Yes.
you have to be treated differently.
Yes.
And that reserve forest was declared in the year 1888.
And we were residing in that particular area since 1976.
Perhaps we will not be able to grant you relief. What is your name?
JB Bharadwaj.
Mr. Bharadwaj, you have to come up with an appropriate case. Okay. Heard 3 JB Bharadwaj, learned counsel for the petitioner. Also heard 3 D. Saikia, learned Advocate General Assam, who was assisted by Sri R. Borputari. Para?
For all the respondents.
Yes. Please have a seat. As per the facts projected, the petitioner is a transgender person and was in occupation of land within the reserve forest of name?
Your Lordship, Rengma Reserve Forest.
Within the Rengma Reserve Forest since a long period of time. Full stop. However, a notice of eviction was issued on 21/7/2025 by the DFO to the father of the petitioner, requiring them to vacate the land within 7 days. Full stop. The petitioners had accordingly approached the DFO on 24/7/2025 and 28/7/2025, praying for resettlement and also for time for reallocation. However, on 1/8/2025, the petitioners were evicted from the plot of land in question. Full stop. The present petition has thereafter been filed with the following relief. Para? Relief code for you. The Bharadwaj, the learned counsel, has submitted that there has been violation of his fundamental rights.
Yes.
And also the principles of natural justice.
Yes, Your Lord.
Full stop. Para? On the other hand, Saikia, the learned AG, has submitted that the area in question is admittedly reserve forest, wherein possession of the present nature is an offense. Full stop. He has also submitted that sufficient time was granted by issuance of notice dated 21/7/2025, and only thereafter the action for removing the encroachment was taken. He has otherwise submitted that the aspect of compensation would not arise at all, inasmuch as the petitioners were in illegal occupation for a long period of time, which itself is an offense punishable under the
Assam
Assam,
Forest Regulations 1891.
Assam Forest Regulation 1891. Para. After hearing the rival submissions, this court is of the opinion that there is no dispute to the fact that there was illegal encroachment on forest area. Full stop. The petitioner has categorically admitted that the area in question is within the Rangma forest. Para. Apart from, without even going to the aspect on the as to whether such possession is a punishable offense, comma, the nature of relief which has been prayed for would require a factual determination which is not within the realm of an adjudication process by this court under Article 226 of the Constitution of India. In view of the above, this court is of the opinion that no relief can be granted in this proceeding, and accordingly, the same is dismissed. First off, it is, however, observed that the petitioner would be at liberty to approach the appropriate forum for redressal of his grievances. Yes, yes.
Any offense? Deeply applied.
I for
impleading my lord. My lord, the opposite party, my lord, he is the present chief engineer in place of
SN Chemicals, SN somehow this is of the view that court is connected as a council. Let it go before some other bench. Not with this matter, something to do with SN Chemicals. Remember the name. Please before near the bench.
my lord.
Mr. Agarwal, you were a counsel for this for long. For a long time. There was some matter with IOC or some arbitration.
No. IOC matter is not with me.
No, long time back, long time back.
I am for the last 20 years.
SN Chemicals, I think Mr. GP Bhomik, was he connected GP Bhomik?
No. This is some Agrawal.
No, our counsel, senior counsel.
GP Bhomik, no. I have not
Let
seen.
it go before somebody else. Remember something. Yes, what is this?
Lordship may pass over item for time being. The engaged counsel is.
IA for what?
I for impeachment.
Implement will pass if it's justified. Whom do you want to implement?
Lordship, I don't know. The engaged counsel is in another court.
You should have your, aren't you in record, on record?
No, Lordship.
Yes, who wants to be implemented?
The state of Mizoram and the forest department. Divisional forest officer, Scholarship Forest Division, Mizoram. Because this.
We have any council of Mizoram here?
Yeah, I am. Yes.
Well, implement this.
Yes, Lordship. Because as per the direction of this honorable court.
Okay. What is your name?
M. Ahmed.
M.
M. Ahmed.
M. Ahmed. On behalf of?
AHMR Chaudhary.
Third Sri M. Ahmed Learned Counsel, who appears on instruction of Sri AHMR Chaudhary. Full stop. By this present applications, implement of the following incumbents has been sought as respond numbers 8 and 9. Incumbent का नाम दे दीजिए ना. यहाँ पे State of Mizoram 1 and 1 and 2 कर दीजिए small loan sponsor. It is submitted that the aforesaid implement is required to have a fair adjudication of the connected writ petition. Para. Also heard Barua, learned standing counsel.
Government advocate Mizoram.
Learned government advocate state of Mizoram, who does not oppose the said para. Considering the above, the instant I is allowed, and the aforementioned incumbents
be included as respondent numbers 8 and 9 in WPC so and so. The learned counsel is required to file amended cost title in the writ petition.
Obliged.
Dispose of, huh?
Lordship password item for time being. Senior is in another court.
Who's your senior?
MS.R. Chaudhary.
Huh?
MS.R. Chaudhary.
Oh, just now?
Yes, Lordship.
Lordship,
Yes.
we will file one short affidavit.
IA for? What is the IA?
IA for stay vacating, Lordship.
Stay
Stay vacating. Okay, for grant time. This is an application for vacation of the interim order dated 35, not 35. What is the order? Order date 25/6.
25/6.
25/6/2025, passed in the connected writ petition. Para? Miss, your name?
S. Shahi,
S.
Sahi on behalf of S. Sahu.
Sahi for Sahu.
Yes.
Miss S. Sahi, then counsel appearing on instruction of 3 S. Sahu, praised for, and is granted how much time? 2 weeks time to file, 1 week time to file objection. Para, list after a week along with the objection. Para, interim order passed earlier to continue till the next date of listing.
Obliged.
Wait, please, Lordship. Lordship, on the last
I don't
page,
know. Yes.
on the last occasion, Lordship, the respondent has directed to submit the final report.
Submit?
The final report before this honorable court was.
Final report.
Order date, Lordship.
Yes, yes.
I pay for the railways, my lord. It was.
I think state will give the.
Yes, yes, it was.
Yes,
for the
state council.
Government council to produce the final report before your lordship. Last
State
occasion-
council, who's there? State
Mr.
council.
K. Sharma, he appeared on the last.
Mr. Goswami?
24.
Instruction received. Final report has been obtained. Final report is there.
Let us sub the report, Lordship.
No, they will not serve you. You have to go to the court. Before it is accepted by the court,
Yes.
you will have notice will be served upon you. The notice will be served by the court. What is the date of the final report? It's 23. Have you received notice from the court?
No, Lordship.
The son is missing. Son is missing. You need to treat this matter with some sensitivity. The final, what has the final report said? At least ensure that notice is served upon the aggrieved persons by the court. Can you get the status when the matter is there? At least he'll be left with some lead where to go.
Yes.
Which date? Okay. What is your name?
AK Hazong, Lord.
A.K. Hazong.
Yes, Lord.
Heard Sri A.K. Hazong, Learned Counsel.
On behalf of the Ghost, Lord.
On behalf of Ms. D. Ghosh for the petitioner. Correct. Pursuant to the last order dated 18/7/2025, Sri N. Goswami, the London State Council, has placed before this court copy of the final report pertaining to Latasil PS case number 161 of 2017 under section 365 IPC. Full stop. The same has been perused. Full stop. Sri Hazong, the Learned Counsel, has submitted that till date his client has not received any notice from the concerned court. Correct? Sri Goswami, can you get the next date in the court? Is it possible?
Actually, he should take the instruction of the client whether he has received any notice from the court. Client will contact us. Yes.
No, then we'll do one thing. We'll close this. Because now, for now. Considering this, in this connection, it would be pertinent to take note of the relief prayed for in this petition, which reads as follows. Para 10, considering the efforts, the above, this court directs. This court is of the opinion that the writ petition can be disposed of by directing the Learned State Council to furnish a copy of the final report to the Learned Counsel for the petitioner, so that proper course of law can be availed by the petitioner if so advised. The writ petition accordingly stands closed. A copy of the final report is also made part of the records. You make 2 copies. 2 copies, give one to him.
But I pay for the respond number 4 railways.
Sri B. Sharma, ऊपर में लिखो. Sri B. Sharma, London Council is present for the railways. And Gussan. ऊपर सबका नाम लिख दिया. Third Sri D. Hazam and Sri N. Gussan and ऊपर एक ही बार लिख दीजिए.
Deeply obliged.
You take a copy, Mr. Hazam. Your senior colleague will give it to you. আমার একটু photocopy করে দিন.
I can 25.
Milord, the matter may be taken up at 2, Milord. I'll appear as petitioner in person, Milord.
Okay. Yes, Mr. Barun. Is something left in this matter?
Nothing.
Milord.
No, this is with regard to the payment
Obviously,
of his
Milord.
retaining and case conducting.
Is there anything left to be adjudicated?
Milord.
There is.
Milord.
Okay, then at 2 o'clock, if he's
At 2
making a request in person.
Milord. Most obliged.
Mrs. Salania?
Mr. Lordship, my lord, last time Lordship indicated
Yes.
that, my lord, whether there has been notification withdrawn or not, my lord. And secondly, my grievance was that they have not paid the solution of the GDAR. I direct to the authority to consider.
But they have not paid as per their affidavit, my lord.
What about the solution part?
Well,
Mr.?
solution, my lord, we have paid, my lord. Our stand is that, my lord, solution has already been calculated and paid. If we are wrongly calculated, they can approach the, my lord, arbitrator under section 3G5 of the, my lord.
That is true, my lord.
Highway.
That
Act,
will
my lord.
close this.
That's the only thing is that where, how they have shown the fraction, my lord.
And
They have shown
that
the,
the
my lord, zero, but not the 100%.
Lordship asks about the, my
They are
lord, limitation, my lord, as the arbitration act is applicable, my lord. Under section 43, my lord, limitation is 3 years from the date of the award, my lord.
No. The arbitrator would be approached
My lord.
against the award as he is aggrieved or he has projected that the solution has not been paid.
Paid, my lord.
You have said the solution has been paid.
Paid, my lord. And we have
This
filed the
aspect-
affidavit, my lord.
This aspect can be looked into.
And
by
we
the
have filed the
affidavit.
affidavit, so there is a limitation is there. We have filed the affidavit in, my lord, on, my lord, in 2023.
You have referred for section 43 of which act?
My lord, arbitration act, my lord.
Arbitration Act 43. Let's see. Yes, please.
Section 43, my lord. Limitation act is shall apply to arbitration as it appears to proceed in court.
Application of Limitation Act.
My lord. And the limitation act, my lord, section, my lord, 137, my lord. 3 years, my lord.
Okay. Heard Sri M. Saranya, Learned Counsel for the petitioners. Also heard Sri J. Chutia, Learned Standing Counsel KAAC. Ms. R. Bora, Learned Standing Counsel NHIDCL, and Sri S. S. Roy, Learned State Counsel. Full stop. Para. Considering the subject matter and as agreed upon by the learned counsel for the parties, the instant writ petition is disposed of at the admission, is taken up for disposal at the admission stage. Full stop. The petitioners, please have your seat, Mr. Sir.
My lord.
Petitioners. Now, as per the projection, the petitioners are residents of Fulani Revenue Circle in the district of Karbi Anglong. And their Miadi Patta land has been affected by the construction / widening of the highway 29, which was earlier NH 36. Full stop. Though certain compensation were paid, the same was inadequate. Full stop. The petitioners have also raised the aspect of the clearance from the road to their sites. Full stop. When this matter was taken up on the last occasion, the Learned Standing Counsel, KAAC had submitted that the grievance of the petitioners were not factually correct, as the solution aspect was also taken care of and paid to each of the petitioners. Full stop. In this regard, he has drawn the attention of this court to the affidavit in opposition filed on 9/11. Is it 9/11?
My lord, 9/11.
2023.
Including-
More particularly paragraphs, the averments made in paragraphs.
Paragraph 13, my lord.
Paragraph 13.
Including the the individual award.
Paragraph
13.
13. Is page 190, huh? Which reads as follows. Full stop. He has also submitted that under the National Highways Act 1956, there are adequate provisions to raise the dispute of present nature if any grievance still exists. Full stop. He had also submitted,
Under section 3G5.
Sri Chutia, the learned counsel, has reaffirmed that the notification dated 23/3/2020, which was a subject matter of challenge, has been withdrawn, and in today's hearing, he has placed before this court the said notification of withdrawal dated 12/10/2023. Full stop. Para. The Ms. R. Bora, the learned standing counsel NHIDCL, and Sri S.S. Roy, learned state counsel, has supported the stand taken by the learned counsel for the KAAC. Para. Under section 3G5 of the National Highways Act, Mr. Bolegi.
1956. 1956.
National Highways Act 1956, comma, a provision is there for approaching the arbitrator in case of any grievance with regard to the amount of compensation. First, for ready reference, the aforesaid provision of law is extracted herein below 3G5, National Highways Act. This court has been informed that the special secretary to the Revenue Department, is he the arbitrator? Has been Revenue Department, got a Government of Assam, has Miss G. Hazarika, learned standing counsel Revenue Department, who is present, has informed this court that the special secretary to the Revenue Department, Government of Assam, has been appointed as the arbitrator.
Secretary. Not special secretary.
Not special secretary.
Earlier special secretary was there, subsequently my lord secretary.
Okay, so you're not doing special. Revenue Disaster Management has been appointed as the arbitrator. Fair. This court has also been apprised that under section 47 is it? 43 of the Arbitration and Conciliation Act 1996, comma, the Limitation Act has been made applicable, and accordingly, and therefore it transpires that the petitioner will still have sufficient time to approach the arbitrator in case of any existing grievance with regard to the solution. In view of the aforesaid discussion and the facts and circumstances noted above, the instant petition is closed with liberty to the petitioner to approach the arbitrator under the aforesaid provision of law. And if such approach is made, the same be considered by the learned arbitrator strictly in accordance with law.
My one prayer, my lord, prayer number 4, my lord, medication. I have prayed for a my lord to direction to the authority to provide the award, my lord, until as I cannot approve, because they have paid the money only in the bank. Therefore, I come to know.
Annexed it in the our affidavit of
As
police.
per the my lord act, they have to individually, the award has to be given to me, my lord, not collectively. That has been directed, my lord.
Since
If any-
at this stage, Sri Saranya has raised the issue that the copy of the award has not been afforded individually
My lord.
to the petitioners.
My lord.
Sri Chutia, the learned Standing Council has however submitted that in the affidavit in opposition itself, the copy of the award has been annexed. Full stop.
Individual award.
Individual awards have been annexed. Full stop. In view of this above, comma.
If
there is
any
no-
grievances is there, he can approach the Kala.
the aforesaid grievance, the copies of the awards which have been annexed to the affidavit in opposition may be utilized by the petitioners to refer their to while approaching the arbitrator in the arbitrator as indicated above. With petition stands disposed of. Yes, ma'am. Not this business.
Kindly, madam, may be taken after 3 weeks, lordship.
After?
3 weeks, lordship, because petitioner was in Delhi.
Hmm?
Petitioner was in Delhi. We are unable to contact him. So,
This type of submission has been made on last 3 occasions, and this writ petition is pending for, we do not know what reason. We have already made clear in the affidavit.
The subject matter has become infructuous.
In fact, my lord, the infructuous is the wrong word, my lord. It was a stillborn. The entire case is based either on a misapprehension or, my lord, misunderstanding. I will not know.
We'll
Let us speak-
dispose it of tomorrow.
Lordship.
Let him.
kindly, my senior is out of discussion tomorrow. So kindly, madam, we may fix first September.
On Monday then.
Monday.
A prayer for adjournment has been made on behalf of the petitioners. Full stop. Sri Ganguly, the learned counsel for the respondent bank has however submitted that the approach to the court in this writ petition was premature.
No, misconceived, my lord. would
Was
be the right
absolutely misconceived, and on earlier and on many earlier occasions, time has been sought for. Be that as it may, in the interest of justice, an accommodation is granted to the petitioner, directing listing of this matter on first.
Pass on this.
Item 29. Yes, 29.
May I please, my lord?
29.
29.
29, Mr. Mullah's case, not your case perhaps.
Sorry.
Yes.
Please, my lord. My lord, the matter here, my lord, the petitioners before all lordships are the, my lord, horse pilgrims, my lord. They performed their horse in the year 2023. Here, my lord, what happened? My lord, the airfare was taken for chartered flight, my lord, but pilgrims were taken by, my lord, normal passenger flight. Now our prayer, my lord, for a direction to refund the excess amount.
Yes.
Yeah, Lordship can dispose of this writ petition by this in the light of the judgment passed by our High Court, Your Lordship.
I have annexed also, my lord, one of the orders, my lord, passed by this honorable court, I have annexed. But this order was passed long back, my lord.
Same is similar, Your Lordship.
Whether refunded or not, any order passed, my lord, not known.
Your representations are still pending.
Still pending, my lord. But in earlier cases also, my lord, similar cases, representation was directed to be, my lord, disposed of. So whether any order passed on those representations, that is the.
No, those were not filed by you. Now, we'll direct consideration of your representation. You make the corrections here because there are factual issues. You have annexed one of the petition copy here.
My lord.
I think, madam, you should give a copy to him.
Yes, Your Lordship.
Make the corrections, both of you. And how many of you are there?
We are here 59, my lord.
59.
59.
Some more matters are also pending, Your Lordship.
That representation disposal, that's a.
Again, my lord, if they say no in those representations, again we have to come, my lord. So all these matters may come together, my lord, and they have filed affidavit, we have filed affidavit, maybe.
We have mentioned regarding this, their queries, Your Lordship.
No, those factual disputes can we adjudicate here? Let them answer your representation first. then you will be a better position to challenge that this is not correct, this is correct. Okay?
Well,
Same order, make the corrections. And a copy. Both of you, Mr. Mola,
well,
take this copy. Take it from madam and correction. Give it to madam, then both of you give it to court master.
deeply obliged.
Yes.
Obliged.
Dispose of.
Item 30.
Item 30. Go ahead.
Yes, sir. This is a case, your lordship, where we have requested the circle officer to demarcate our plot of land, which is not done since long, your lordship.
Notice was issued. Yes, have got any instructions?
My lord, instructions awaited, 2 weeks further time available.
Get the instructions. Notice was issued on 30/23/7. Let him have the instructions. Third, 3. Age Buragonash, Senate Council for the petitioner. Full stop. In this case, notice was issued on 23/7/2025. Para 3. So and so, your name?
P. Hazarika on behalf
3
of.
P. Hazarika, Learned Council, appearing on instruction of 3 S.R. Rabha, Standing Council BTC. However, prays for some time to enable him to obtain instructions. Para list after 3 weeks.
Obliged, lordship.
Charlie?
Net is a loss.
Yes.
That we have filed our rejoinder, my lord, and it has been tagged, my lord.
Tag not, tag kar nahi.
Police, yes.
Aichen. Tag is
Their file rejoinder, it's been tagged with the records. What is
But
the
they have
matter?
not complied the order of this on court. This on court, my lord, directed to produce all documents, my lord. Regarding their claim, the government claims that the land, my lord, is government land. Our claim, my lord, this is a private partner land, and they have changed the ROW. And they have encroached our private land.
Yes, Mr.
But
Stated that we have not encroached lordship, we have
No.
filed our affidavit. When disputed question of facts are coming.
no record will reveal whether this is government or private, my lord. We have submitted our document that this is a private land.
This is.
And therefore, this all court, my lord, directed to produce all relevant documents, my lord, by
My
filing a affidavit.
Uh,
That was not done, my lord, till date.
Affidavit has been filed with
My
No
lord.
record, my lord, only mere statement, my lord, which was earlier also made.
No, by records, what can you prove? You have your record that it is Patta land.
Lordship,
Now they have stated that your Patta land has not been encroached upon.
lordship.
Now that part, how can you demonstrate by the records? That is a factual assertion.
Now, deputy commissioner is the, my lord, authority, my lord.
That is why they file affidavit.
We have filed lordship.
But
If
they have
they
not
say,
dis-
if they
Lord-
say that your Patta land has not been encroached, then you say that Patta land has been.
Lordship.
This is a matter of word of mouth, like him against you. You may be correct, he may be correct. But the records, both of the records will be correct. You have a Patta of your land.
Lordship.
They are having some other records. But how do you produce, how do you prove that there has been encroachment of your land without following the due process?
Because, my lord, one report from the circle officer said that during, my lord, construction of ROW, my lord, they have, my lord, exceeded the boundary, my lord.
We have clarified in the additional letter.
My lord, here circle officer is the not authority.
We have
Is
clarified.
the
in our
authority,
affidavit.
deputy commissioner, and
no.
more particularly here, my lord, competent
Ali
for land
may have-
acquisition.
he may draw support from the report of the
Because
circle officer.
circle officer prepare report on the
Why is-
basis of, my lord, report of Latmundal, my lord.
But whether we will be able to adjudicate here
My lord,
in red jurisdiction.
my lord, here this we are suffering because of this unable to go for construction. That is, your lordship also aware, due to this interim protection, we are, public works has been hampered. That is also question is to be, if any damage or anything is to be caused, payment, he will get the payment only, no option, my lord. Land we have to give, even my land I have to give for my, that is no option. Suppose in regard of payment, if he's claiming payment or other things, this, if that particular, my submission is that land is required, let it be government or private will. In case of private, we have to pay them. That is to
What
be
what is the
decided.
interim order? Is there any
Interim
interim?
not to demolish, not
Demolish
to
the
go
building.
for, not
My
to,
lord, here, my
thereby
lord.
entire work is being held.
No,
my lord.
no.
That is our
Construction
submission.
has been completed except, my lord, the demolition of the building.
You will not,
we have-
you will say will not work out.
We have
Because
photos,
I
my
am the
lord.
constructing agency, my lord.
We have photos.
I am saying, my lord, why I'll go for,
What are your photographs? Let us see.
why we
Give us the man.
demolish, my lord, we will demolish, my lord.
And subsequently, they have completed, my lord.
No. Not complete. That particular portion is left. And we also produce for you. জিপি নে কি কয় এইটো যে লয় যে কি ফটোগ্রাফ
What is your boundary, Mr. Ali? There is no boundary.
And already, my lord, demolished, my lord. That part, still as have already been taken away.
But from the footpath, at least 6, 7,
No.
what's 6 feet?
Now, this is, my lord, new construction.
Your roof is at least 6 feet,
This is, my lord, new
not
construction.
6 feet, around 12 feet inside the house.
And, my lord, in the
No.
notification, my lord, 3D,
Not
my
the
lord.
footpath.
Lord, on the 3D notification, my lord, this land was not included. CA 3D, no.
Mr. Ali, if
Lordship.
some land is required for public purpose,
Lordship.
we are only concerned whether public purpose is there or not. Whether there is involvement of malafide. There cannot be involvement of malafide. It's not that your land has been specifically taken and somebody else's land have been worked out. If it's in the right of way, you would be entitled to a fair compensation. That is what we are concerned.
Lordship.
How can you resist? And when
No.
only because of your this particular structure, the project is at a hold.
Now they have, my lord, issued a letter, my lord, saying that I am not entitled for any compensation. In
That
respect,
you can challenge.
therefore, we have filed this
That you
case,
can
my lord.
challenge.
No, that can be challenged, lordship may point out.
That part will still be
If
open.
by
but
putting it on record, that can
No,
be
no,
challenged.
we have annexed, my lord, the letter, my lord.
That challenge will keep it
Lordship.
open. We'll keep it open.
Lordship.
Whether you are entitled or
Annexes,
not.
annexes
That
6,
part
my
may be
lord.
kept open, my lord.
Third,
If he is entitled.
we are Ali learned conflict for the petitioner.
I'm for 1, 2 and 3, my lord. Standing counsel and I said,
Also heard. Sri C. Barua, learned standing counsel,
NHIDCL
NHIDCL,
for 1, 2 and
NHIDCL
3.
for
My lord.
comma,
Yes.
3 SS Roy, and 3 SS Roy. You're there, madam, semicolon SS Roy, learned state council, and Miss G. Hazarika, learned state, learned standing council, revenue department, SS Roy state council. Madam? Where is the challenge? That is, you are not entitled to any compensation. Which part of the prayer?
My lord, page 37, my lord.
No, paragraph 12, page 12, your prayer.
No, paragraph, prayer number 2, my lord, will cover, my lord.
Direct to determine the compensation. There are other also. Where is the stand that you are not entitled to any?
Page 37, my lord.
37.
Serial number 4.
37.
7, 4S. Petitioner is in.
Serial number
4, my lord. That number has been wrongly written by the authority, not by the petitioner, my lord.
But this notification of 24/8/2024 is not under challenge. Why didn't you challenge this? You challenge whether you challenge in a writ proceeding or you challenge in a civil proceedings, up to you.
Because if this is there, they
Prayer
can
num-
stay, they tomorrow, even if there is a direction to consider, they will say that we have already notified, unless this is put to challenge. This dark 20 is your dog.
200, my lord.
200.
Huh?
It should be 200.
200
They have
actually, my lord. We also clarified it. One place we write 20, but we have later on clarified that is 200.
This should be 200.
200. There is no
Then
doubt.
you
in
challenge
that.
this.
There is no doubt in that.
You challenge this. So far as your entitlement to compensation is concerned,
Yes.
that is a matter which might require
Yes.
an adjudication.
That may be
Whether
kept
it's
open.
done by this court or any other court is a different matter.
That may be kept open.
Uh,
But interim may be vacated,
Yeah.
so that we can go for work, my lord.
Yes. The instant petition has been filed with the following prayers. Paragraph 12, page 12. As per the facts projected, land of the petitioner measuring 0.0115000 hectare covered by DAG number 123, PP number 22 has been acquired acquired under section 3D within bracket 1 of the National Highways Act 1956 by a notification dated 8/8/2023. Full stop. Such acquisition has been done for widening public construction of a 4-lane highway and ancillary purpose. Full stop. It is the case of the petitioner that at the time of execution of the road, the ROW, right of way, was changed, whereby a portion of the land of the petitioner covered by DAG number 200, PP number 2 of village 2, number Miri Taco, has been taken to be on the way, and accordingly, the structure standing over the said plot of land has been sought to be removed. Full stop. The petitioner has also relied upon a report dated 28/5/2024 issued by the circle officer by stating that the aforesaid land and that the right of way has exceeded in some areas, whereby the aforesaid land has been affected. Full stop. Sri Ali, the learned counsel for the petitioner, has submitted that the right of way cannot be changed in a whimsical manner, whereby the petitioner would be adversely affected. Full stop. He has also relied upon the report dated 28/5/2024 of the circle officer. The learned counsel has also submitted that in the affidavit in opposition filed by the not affidavit. He has also drawn the attention of this court
In the notification.
to a notification dated 24/8/2024, whereby the NHIDCL has stated that for the area in question, the petitioner, the aggrieved party, the concerned party would not be entitled to any compensation, as it comes under unauthorized occupation, encroachment. Full stop. He has clarified that though the description of the land has been written as DAG number 20,
there has been rectification in subsequent documents that the DAG number is actually 200, which is the subject matter involved in this writ petition. Para? Sri Barua, learned standing counsel, NHIDCL, has however submitted that the ROW has not been exceeded and the construction has been done strictly in terms of the requirement and formalities. So he has also submitted that the communication dated 24/8/2024 issued by the general manager was done after proper verification and inspection, and he admits to the and he clarifies that in the affidavit itself filed by the NHIDCL, it has been stated that the DAG number was wrongly written as 20, which should be 200, full stop. He submits that the structure is upon an encroached part of government land over which the petitioner would not be entitled to any compensation. He has also submitted that the present writ petition involves questions of fact which are disputed and may not be gone into by this court in exercise of powers under Article 226 of the Constitution of India. He has further submitted that under the National Highways Act of 1956, there are avenues and provision for redressal of grievance of this nature. Both Sri S.S.
One
Roy.
more submission was there, Miller.
Which one?
Since it is a public proposition, and I would like your lordship know, another expert clearly said, once it is a public property, there should not be justified in his claim.
He has, Sri Barua has emphasized that the project in question is of utmost public importance. And public interest would override the private interest, if any, of the petitioner. Full stop. Sri S.S. Sri Roy, the London State Council, has supported the views of Sri Barua and has submitted that you have also filed affidavit.
Yes.
That the affidavit in opposition has also been filed by the respondent number five, opposing the prayers of the petitioner.
There was a joint verification in 16/8/2025 in terms of court's order, lordship.
He has also drawn the attention of this court to the joint verification done on 16/8/2024, which was in terms of an order of this court. And in the said verification, it was revealed that the structure was on
Government.
On government.
50% government and 50%
that
private.
part of the structure was on government land. What's the para? After hearing the rival contentions from this court is of the opinion that the area in question covered by DAG number 200, which is the subject matter of dispute, full stop. While the petitioner has contended that the said area is exceeding the right of way, the respondents have asserted that the area is within the right of way, full stop. The project in question is, without any dispute, a project of grave public importance. And it is a settled position of law that public interest would override private interest, if any, full stop. Even if the petitioner raises a dispute that the area in question is part of the Pata land, comma, the petitioner would have adequate, would have to approach the appropriate forum for ascertaining and determination of such rights. Full stop. The said aspect having fallen within disputed questions of facts, comma, this court may not have the expertise to go into such aspects. Full stop. Para. This court has also noticed that while entertaining this petition on 2012-2024, comma, an interim order was passed directing the respondents not to proceed to take over the land and remove or demolish any building or structure standing till the next date fixed, and the said interim order was extended from time to time. Full stop. Having noted that public interest would override private interest, comma, this court is of the opinion that continuation of the interim order would not be justified, and accordingly the same is vacated. Full stop. The writ petition accordingly stands dismissed. Full stop. At this stage, however, Ali has again referred to the notification, to the communication dated 24/8/2024, whereby the NHAIDCL has come to a finding that that part of the area in question is government land which has been encroached by the petitioner. Full stop. The petitioner would be at liberty to challenge the aforesaid finding, and based on such challenge would be entitled to raise a claim for compensation in accordance with law. Full stop. The petition stands closed.
Right.
All of you present here. There's some bar meeting. You're not interested in the bar.
My lord, I am praying for adjournment of my case, my lord, since, my lord, the meeting is going on, my lord. So,
That is why we had sat left, were requested by the bar. Yes, Mr. Boro?
So it is on his prayer, it has been fixed at 2. I kept
Lord,
waiting, in fact, I was
in
having
Lord,
other
that
matters.
meeting is going on, my lord. And further, another thing, my lord, I could not recollect, my lord. Your lordship may not like to take up this matter. Earlier, my lord, against the Pollution Control Board, my lord, your lordship, lord, regarding that fee, payment of advocate's fee,
Yes.
my lord, your lordship may not like to take up this matter. my lord.
Why?
My lord,
I'm not really interested in Pollution Control Board.
Refusing
is something which has to come from my conscience.
my lord, then my lord,
If I think that if this court thinks that there is no prejudice will be caused to any of the parties,
my lord.
leave the decision to this court. We'll adjourn it if you want.
On 3rd, my lord, 3rd of
Uh,
September.
Okay, on a request made by Sri P.J. Fukun, petitioner in person, matter is adjourned to 3rd of September.
September.
The as Bureau and Standing Council Pollution Control Board is present. So as along with Sri S.S. Roy for the state.
My lord, why I, my lord, indicate, my lord, on that occasion, my lord, your lordship appeared on behalf of my friend, my lord, regarding.
Is he a party here?
I'm not a party.
My lord,
I'm a counsel for the board now.
that was, my lord, regarding a standing council of Pollution Control Board. That is why.
Is he a party?
No, my lord.
Then wherever Mr. Barua appears, I will not be able to take.
In analogous case, my lord, he was made, my lord, party, my lord.
No, is he a party here?
My lord,
in this proceeding? Council
don't
is
have-
appearing. What kind of submission is this,
My
Mr.
lord,
Fukan?
I'm just indicating.
You are senior enough not to make this kind of submissions.
No, my lord, I'm just indicating.
What is the indication? Tell us what is the indication?
My lord, I don't have any objection, my lord. If
No,
your lordship-
why then why are you raising this?
No, since I as a court officer, I should indicate, that is.
What is there to indicate?
My lord,
Will your
otherwise-
conscience allow you to indicate this kind of matters, petty matters?
No,
We
my
find
lord.
it this is very petty thinking.
But from my perspective.
Your
My lord,
colleague on the other side was a party in this from proceedings.
everything boils down to one thing, my lord. I am ready to, my lord, argue before your lordship, my lord.
Then why are you raising these unnecessary issues?
No. On third, my lord.
We have already fixed your case.
My lord.
If you want, you can go for any other bench. We have
No, my lord.
likening before of this particular
Lord.
case before this court, not at all. The last court to have a matter attached to this court.
No, that will be my lord, not.
I think that should be the order.
My lord.
Please before any other bench.
No, my lord, on third, before your lordship, my lord.
Please before any other bench. Lord.
Lord, I am extremely sorry, my lord, the matter may be taken
You
up by
should
your.
be sorry.
My lord, most obliged.
Gladly, your lordship. My lordship, kindly peruse the page number 48, my lordship.
This is item number
32, my lordship.
30.
32.
32. Abul Hussain Laskar. Yes,
Yes.
what is it?
Page number 48 may be seen first, my lordship. Actually, my lordship, pursuant to a neat notice inviting tender that date 29/6/2019, my lordship, we have been allotted the showroom. The respondent, the private respondent had earlier approved before the Honorable High Court. Page 48, I have annexed the order, my lordship. Honorable High Court dismissed their petition. Operative person is.
Now, what is your now grievance?
Grievance is that, my lordship.
You have not even handed over possession.
Yes, my lordship. Pursuant to that notice inviting tender.
Yes, you for whom?
Lordship for the PNRD.
PNRD.
Mr. S. Datta.
Huh?
On behalf of Mr. S. Datta.
As Datta. Yes,
Lordship,
what instructions?
Instructions are awaited, Lordship. I'm paying for some time in this matter.
My lord, I have filed.
Get the
this-
instructions matter. This notice was issued in February.
Lordship, we have-
We are in August, end of August.
They have gone to Supreme Court also. Supreme Court also did not interfere, my lordship. And Honorable High Court
Okay.
has
Hartsbury SB Laskar, learned counsel for the petitioners. Sir, your name?
A.K. Ghosh.
Sri A.K. Ghosh, learned counsel appearing on inspection of Sri S. Datta, standing counsel PNRD, has however submitted that instructions are awaited and he accordingly prays for some time. Yeah. Sri Laskar, the learned counsel has expressed urgency in the matter and has submitted that in spite of earlier round of litigations, the possession has not been handed over. Possession of the shop. Considering the above, matter is adjourned to be listed when?
It's after 2 weeks, Lordship.
Listed after 2 weeks. Come up with instructions.
Obliged, Lordship.
my lord, if possible, any date, my lord, if possible.
Dave? Okay, on 10th, 2 weeks. This on 10th.
Obliged, Lordship.
Highly obliged, my lord.
My lord, as per order 5/8.
Yes, we remember this matter. Yes.
My lord, our instructions that the bank has complied with the notification, my lord. What happened, my lord, the loan was sanctioned in the July 2023 and subsequently defaulted in the November 2023. In January, we have inspected the premises, the unit as per the MSME rule. And during the time of inspections, we came to know that that particular unit was actually closed on that time in the month of January. And since we try to contact the persons, broad, he do not reachable. So subsequently, the corrective action plan is not feasible on that side. So ultimately, the accounts becomes NPA in the month of March, and subsequently, we waited till 1 year, and after 1 year, we filed the commercial suit for the recovery. Here, the default amount and the default is not under dispute. They agreed on that. So ultimately, for the recovery of the bank's public money, we approach after 1 year. That document is.
But he is making out a case on a different ground. That requirement to be followed if the borrower is an MSME.
Yes.
My lord,
That has not been answered, my lord.
No, that is answered, my lord. My lord, his contention is that the amount below 10 lakhs.
Yes.
There's a two part on that. Number one part, below 10 lakhs, the bank branch manager has to go through whether the corrective actions plan is required of it. However, in case where the branch manager has decided option of recovery under the corrective action plan, if under the corrective action plan, then only he needs the concurrence from the committee. In this case, the corrective action plan not feasible. That's why they have not gone on that.
Have you stated this on your affidavit, in your affidavit?
My lord, earlier I have filed
You
affidavit.
filed affidavit of on 2025. He has also replied to that.
Yes.
But this point you have not answered.
Because on that time, their statement is only in respect of MSME, that part. We stated on that since they have not approached us before NPA.
Yes.
Stating that this borrower is under SME and that, my lord, in the
Are
judgment
you
of the
meaning to,
Honorable
are you
Supreme Court also, my lord.
are you trying to contend that you are not aware of the status of the petitioner as MSME?
No, my lord, we are aware. But in this note, as per this notification, even though they can approach the bank that we are the MSME and we will get this advantage. On the part of the bank has already inspected the premises. My lord, this complete notification for the rehabilitation and restructuring of the loan. Once the
Mr. Sharma, that is the purpose of giving notice in a case. The purpose of notice is what? To place your case. You have not stated this in your affidavit.
I will file.
No. Is there any scope of filing another countless affidavits?
My lord, no, my lord, at that time.
If you do not meet the point in your affidavit, why should we give you another opportunity to improve your affidavit?
But my lord, in my affidavit, I have mentioned that I have complied with all these things since they have not approached us on that time. That part is there. But the countless of loans are there. So once the borrower is silent and willfully defaulted or not approach the bank.
How much is the amount?
8 lakhs 40. They can approach the bank for the settlement also.
Why did you approach?
We can approach, my lord, if they're willing to consider this process, my lord.
That is their
they will
willingness
have
to approach.
We will approach, but they will have to
We
follow
approach,
the
we make an
notification.
observation.
Yes,
We
ma'am.
try to
That
settle
can-
the matter.
Yes, ma'am.
Yes, ma'am.
8 lakhs is not a very big amount.
Right, ma'am.
And you are an MSME. They would probably have various other schemes for consideration of loan of this nature.
Right.
Okay. Third, Sri I. Botakur, Learned Counsel for the petitioner, as well as Sri B. Sharma, Learned Counsel for the respondent bank. Though the affidavits have been exchanged, Sri Sharma, the Learned Counsel, has submitted that certain relevant aspect regarding decisions taken by the branch manager and collective action plan were not adequately dealt with in the said affidavit. He has also submitted that the amount involved is around 8 lakhs. And therefore, until now, the petitioners have not approached for a settlement. Sri Botakur, the Learned Counsel for the petitioner, has submitted that his client is not opposed to any settlement. In view of the above, the petitioner is directed to approach the respondent bank with a proposal for settlement within a period of 2 weeks from today. And if such proposal is made, the bank may consider the same. And both the parties would make an endeavor, a sincere endeavor to settle the matter. List this case after 3 weeks.
Well,
Settle it,
a small amount.
small amount.
Problem.
May it please, Your Lord. Also, here the petitioners are aggrieved by the inaction on the part of the respondent authorities in not executing the eviction notice dated 16/6/2025, Your Lordship.
Please come again.
Inaction on the part of the respondent authorities in not executing the eviction notice issued on 16/6/2025, Your Lordship.
Okay, the eviction notices were issued at your instance, so what?
Actually, Your Lordship.
Who are you?
I am the supplement holder of a plot of land measuring 4 kathas 7 acres.
It was encroached.
It was encroached by the respondent number 4. Now they are running a daily market from that particular plot of land.
There's an order.
There is an order, Your Lordship. In fact, they have approached the learned court below before the civil court. And in that case, Your Lordship, we are the defendants. And that particular suit, title suit number 12 of 2022, has been dismissed on the ground of rejection of claim under order 7 rule 11. And subsequently, the notice has been issued by the municipal board to the respondent number 4 to vacate the premises.
I have the instructions, Lordship. They have filed another suit that is also pending. Lordship.
Now that suit, Your Lordship, they have filed it after passing of the order in the earlier suit, Your Lordship. And this particular suit, they have filed under suit for declaration of right title interest under adverse possession and perpetual injunction, Your Lordship.
Is there any injunction?
No, Your Lordship, there is no any injunction. In fact, we have appeared, we have filed our wakalatnama before the learned court.
If the case is pending, so what, you filed your affidavit?
We'll file it. Recently, I have it.
You have filed?
No, we'll file that. That's
File your affidavit. Take these into consideration in your affidavit. Arts G. Borderland Learned Counsel for the petitioner. Sri N. Goswami Learned State Council has however submitted that against the eviction notice, the respondent numbers 4 and 5 had instituted a title suit.
Lordship, more particular, respondent number 4 they have filed.
4.
Both the suits, even the pending suits in the earlier suits also.
4. Respondent 4 had instituted a title suit, which however was rejected under Order 7 Rule 11 CPC. However, thereafter, another title suit has been instituted.
3 of 2025.
3 of 2025. PS 3 of 2025 in the court of?
The Civil Just Senior Division, Dhemaji.
In the court of Civil Just Senior Division 3, which one of the relief as in the is perpetual injunction.
That suit is between the two parties, Lordship.
Yes. Sri Goswami, Learned State Council, according to praise for, and is granted 3 weeks time to file the affidavit in opposition.
Article 26.
Mr. Ahmed.
Matter, without declaring our lands, they have to firstly take positions for it. And last occasion, my friend was asked to bring instructions.
Yes.
Instruction
in Yaripatla land you are using it
land without
acquisition.
Yes. We have no objection. They let they acquire and get the compensation. Already they take position. First
I don't have any written instruction, my lord.
You have
written instruction, I don't have it, my lord. The instruction is awaited, my lord. Because something
okay,
has.
Notice was issued. You file your affidavit.
Lordship, I'll file my affidavit.
Court Sri J. Ahmed Learned Counsel for the petitioners in this case, where notice was issued on 1/8/2025. On the prayer of Sri S. Bola, Learned Standing Council GMC, matter is adjourned by 3 weeks to enable him to file the affidavit in opposition.
Fix them after
3 weeks.
Date may be given.
On 22nd. Not 22nd. Last week will be difficult for you. On 19th. 19th September.
Hello.
Yeah, please, your lordship. In this case, learned advocate generals are supposed to appear, my lord. Today he has some difficulties, my lord. Let it be on 2nd of September, my lord.
Second, let it be on 5th.
No,
Second
that-
hours.
I have to confirm, sir, for date, my lord.
When?
Let it be on 5th because, my lord, if their second is their problem, so, my lord.
Second,
we
I
have
pray
the-
for second, my lord, Tuesday.
Say they are paying for second you are around?
My lord, some problem is there on second.
Will accommodate you?
My lord.
Will you come to the court or not? Will not come.
My lord.
Is it such big a problem that you cannot even come to the court?
No, my lord, if
Are
a
you
lordship
going to-
direction is there,
Are you going abroad?
no, my lord. Let
Yes.
it be on 4th, my lord.
My lord, may I pray, my lord? We are being led by learned senior counsel, my lord. He has prayed before my lordship, so after 7th, any convenient date, my lord.
I have to confirm with, sir, my
Get a date of your convenience. This should not be an dispute.
My lord, my lord.
A joint request for accommodation has been made on behalf of the parties. List on ... Interim order passed earlier to continue with the next date. Give the date
My-
of your convenience. Just talk to and come over.
My
My
lord.
lord, obliged, sir.
Wait, please, Your Honor. Lordship, on the last occasion, there was an order to take necessary steps against the respondent number 10. You know, it needs some time to take instruction from the petitioner, Lordship, because there is no communication. We have not established any communication with the petitioner now. We need 2 weeks' time, Lordship.
Where do you want time? Time for?
Take the necessary steps on respondent number 10.
Are you in touch with your clients?
Yes,
2018 matter.
yes, Lordship.
If you have not taken steps since 2018, why should we give you time? What is the matter about?
Lordship, it's a here we have challenged an impugned order dated 26/12/2017, passed by the Chief Executive Officer, Guwahati Metropolitan Authority, which is also the respondent number 3. Page number 3. Page number, annexes 6, 7, 8. Page number 6, 7, 67.
It's already been demolished. What is your prayer?
Lordship, I'm actually appearing on behalf of P. Das Lordship, and I'm well not acquainted with the facts of the case, Lordship. So Lordship, may just give us some time so that we can just communicate and
Page number 69 is the final order of the passed by the GMTA.
Yes.
And for this, the provision are under section 73 appeal lies. The GMTA. There is a statutory provision.
No, you come to the prayer, Mr. Bora, at page
Yes,
20.
prayer also, my lord.
Prayer, what is this prayer? Can it be given now?
No,
Just see.
no.
The illegal orders to set aside its demolition have already been taken place.
Already taken by the court. At that particular moment, it is a challenge this particular order, my lord, 26/12/2017.
Register an FIR, we do not
Yes.
know what has happened. Where is your senior? Where is your colleague? Who appears? PDAS.
Yes, Lordship.
Where is he?
He's out of station, Lordship.
We'll have it on Friday. We'll close this.
Look,
Much obliged.
Have you taken steps? You have not even taken steps.
Lordship, we have no instruction only. We have not established any communication with the
Client.
petitioners.
That is it.
Just
I think we can close it.
no, because that section 71, they should have been looked at that particular point of time. Now it has been demolished. There is no objective.
What is your name?
G dash, Lordship.
Sri G Das Learned Council has appeared on instruction of Sri Fidas for the petitioner who submits that there is no instructions from the client. Full stop. This matter, writ petition is pending since the year 2018, and the prayers in the petition have also been perused. Full stop. It also transpires that no steps were taken for service of notice upon the respondent number 10, in spite of notice being issued in the year 2018 itself. Para? Considering the above, this court is of the opinion that the petitioner is not keen to prosecute the case. Full stop. Accordingly, the same is dismissed for non-prosecution. Yes.
No, I appear for 3 and 4 now.
Sri S. Bora.
What three?
Standing Council,
Yes,
GMC, and Sri
and GMDA.
GNC, GMD, and Sri J. Henry Clan State Council are present. If the client comes, we can restore it. We have not said anything on merits.
There is a delay of 105 days.
Review.
Review. My lord, I am aware of the limited jurisdiction of the review matter.
Review for what?
Review for the judgment passed by you.
No, let me understand. Review under what grounds?
My lord, the ground, your lordship may see which, no, before that, my lord, your lordship, I think, we like to see the delay petition.
Delay is okay, but
the ground of, my lord, the review.
Delay we can condone and we can dismiss the review.
That I'm leaving up to your lordship, my lord. Even I was
Delay will not delay. There should not be any difficulty from this court. What are your grounds of review?
I was indicating to my learned friend the same thing, my lord, because
What is the review?
that
Review
your
grounds.
lordship will find it para 3, my lord, of my review petition.
Review petition.
Yes.
Paragraph 3.
Paragraph 3, my lord.
The judgment was on an appeal.
Yes.
MSC appeal.
Yes, MSC. That from the perusal of the claim petition, it is very clear that deceased had 2 elder brothers, that is respondent number 1 and 2. And in fact, respondent number 5 was dependent on respondent 1 and 2. In order to get the compensation, it had waived out a case revealing that he was absolutely dependent on the income of the deceased, which fact cannot be relied at all, and under such circumstances, he is entitled to compensation for the loss of state on the death of the deceased. These important facts is required.
Now, what are your grounds? Come to your grounds.
The ground I want to
You have
say,
stated the principles of law. There are no grounds.
that is, my lord, the
You have
roundabout,
only given principles of law when review can be filed, when review is made.
that is, my lord, your lordship is very right.
No grounds at all. See the grounds at page 4, we thought that there were grounds.
And the grounds, my lord, these are all
Which ground? There are no grounds.
that A, my lord, ground A, your lordship can.
Can you read? These are principles of review.
The principles of review.
Where is the ground?
My lord, in fact, we are relying on para 3 only. In the grounds, we just shown the principle of law.
No.
Where
You have to review, to make out a case for review, we have to, what equal rules? What equal rules?
in the grounds, your lordship will find. These
Which
are all,
ground? Please read any
these-
one ground.
No, my lord, these are the all what appeals court has see.
Principles.
reiterated.
Principles, we are aware of principles of law.
True, very, very true.
So for order 47, rule 1, the lordship is indicating possibly that.
No, no, no. Yes, trying to indicate something else. Okay, for this.
Lordship may look at section 114 also.
This. Yes. You have the Guwahati High Court rules.
What area rules?
Yes, have you got Guwahati High Court rules? Have you seen the application for review?
Yes, ma'am.
There should be something else.
There are not sufficient grounds for
We are not on grounds, but we are on the requirement, procedural requirement in filing a review.
Yes, ma'am.
What is it? Under the Guwahati High Court rules.
Guwahati High Court rules, ma'am, not with me now.
Please have a look. Please read, Mr. Doctor.
Yes. The provision of chapter 4 shall apply so far as may be to every application for review. Every application for review of judgment shall set forth plainly and concisely the grounds on which a review is sought and shall contain a certificate by.
Yes, shall contain a certificate.
Yes.
Where is the certificate? Oral certificate.
Yes, yes.
Oral certificate will not do.
My lord, we are dependent on our learned colleagues and time to time, my lord, so many persons come and gone. My lord, we rely on them and it's our fault that we don't check it. You know, these are the procedural infirmities your lordship has pointed out very correctly.
Review itself is a very, very technical thing.
Yes, yes.
If you don't go by procedure, what will you go by?
Exactly, my lord. I hold on to your lordships, my lord. These are the things should be checked by us.
We condone the delay, we reject dismiss the review. Heard 3 as Dr. Leonard, Senior Counsel for the applicant, assisted by Madam Bora. K. Bora. Also heard
BK Jain.
BK Jain, Leonard Counsel for the
Opposite party 127.
127. Mr. Goswami?
Yes, no, 9 lords.
As well as R. Goswami, Leonard Counsel for respond number 9. This is an application for condonation of delay of 105 days in preferring a review against the judgment and order dated 30/2/2019 passed by this court in MEC Appeal number 84 of 2014. The learned counsel, Senior Counsel has drawn the attention of this court to the averments made in paragraph 4 of the petition. Full stop. Of the petition and has submitted that because of reasons which were beyond the control of the applicant, comma, the delay has occasioned. What's the para? Both Sri Jain, the learned counsel, both Sri Jain and Sri Goswami, learned counsel for the respondents, have submitted that they would not have serious opposition on the aspect of condonation of delay, but has submitted that the review itself, a review is not maintainable. Para? It is a settled position of law that application for condonation of delay are to be considered in a pragmatic and justice-oriented approach. Full stop. At the same time, this court is also required to take into consideration that a litigant is required to be vigilant so that third-party rights are not affected, are not created in the meantime. Correct? Be that as it may, after perusal of the grounds of condonation, comma, the instant application for condonation of delay is allowed. Full stop. Application stands disposed of. Para review. Third, Sri Sri Dr. the Learned Senate Council has submitted that the award, which was the subject matter of challenge in the connected appeal, submitted that public money is involved in the award, which was the subject matter of appeal. Full stop. He has contended that there were certain important facts which required adjudication, as initially the claim petition was filed by the mother, who was the only claimant who could claim compensation on the death of her son. And after the death of the mother, there was no person who could claim to be dependent on the income of the deceased. Para? Sri Jain, Learned Counsel for the respondent numbers 1 to 6, 1 to 7, and Sri Goswami, Learned Counsel for the respondent number 8, have, however, seriously opposed the prayer for review of the judgment and order in question. Para? The law on the aspect of exercising powers of review is well settled. Full stop. In this connection, one may refer to the so-and-so, having taking into account the settled position as laid down by the Honorable Supreme Court, this court has also noted the grounds for review, which are extracted herein below. Ground that pays for para. None of the aforesaid 4 grounds can be the aforesaid 4 grounds can at best be treated to be the principles to exercise powers of review, and is not at all connected and is not at all linked with the facts of the case. This court has also noticed that under the High Court rules, there is a requirement to certify the grounds by the advocate, by an advocate, which is also not done in the present case. In view of the above, comma, in view of all the aforesaid facts and circumstances and the discussions made, this court is of the opinion that the present case for review it does not warrant any indulgence, and accordingly, the same is dismissed.
Obliged. Hello, there was also an allied matter for enhancement of competency, the MSC 115, along with this matter. That is fixed for hearing matter.
It's in 115. Is
115,
it listed?
item 43.
Item number 43. Item number 43, you right? 115, okay. 115, you right? Placed before the appropriate bench.
Obliged.
That is still pending.
Yes, my lord, fixed for hearing.
Placed before the appropriate bench for hearing. 12 matter.
Yes.
2012 matter.
Yes, ma'am. My lord, unnecessarily it was tagged with this. That's the reason.
Item number?
44, Your Honor.
Yes, please.
44. May I please, Your Lordship? Lordship, this rate petition relates to ex gratia beneficio, my lord. My lord, petitioner daughter was away by the.
Lordship, may I submit one thing? In this matter, Lordship, BTC is the main party, my lord. Their name not reflected in the list.
Name is not there.
Lordship. Therefore, respond number 3, my lord. Secretary.
Okay. We'll have the BTC on board and we'll have it on Friday.
Lordship.
Okay.
Reflecting the name.
In this case, comma, do BTC is a party respondent, comma, name of standing council BTC is not reflected in the cause list. Para, list on Friday by reflecting the name of standing council BTC. Obliged. Forty-six, yes.
May I take a look? We had sat notice, Your Lordship, and.
You have effected service on 1 and 2 in corrected address.
Yes, Your Lord.
When did you do?
Lordship, I have called for on 19/8/25, Your Lordship, for attend the committee.
For?
For attending the committee, medical committee. And I was attended on 21.
No, it's not that, madam. On 16/7/2025. This is item number what?
46.
697, a big gun.
46. Your Lordship.
That you wanted to serve notice on respondable
Yes,
1
Your
and
Lordship.
3.
Yes, Your
You have
Lordship.
done
We have
that.
already sent.
Then you were called for a meeting.
Yes.
What happened in the meeting?
There was no medical expert was present there, and disability certificate was not issued.
1 and 3 has been served or not?
Yes, Your Lordship, sir.
No, there's, how do you make this submission? They have been served. 18/8, there is a notice. Neither ID card nor unserved notice. Where is the office note dated 18/8/2025, as per which neither AD card nor unserved notice has returned from respondable 1 and 3. Para? In view of the above? List. After 2 weeks with fresh service note, service report. Yes.
My lord, they have filed an affidavit. Let it come along with the affidavit.
Okay.
In this case, state has filed an affidavit.
You have filed?
Yes.
Today morning. Served copies?
Yes, we have got it during the course of the day.
Otherwise, Lordship, this IA has no connection with the main case, Lordship. IA, main case is against demolition order.
And IA?
IA has been filed challenging an order passed by the GMD authority cancelling the land sale permission.
Cancelling the
Land sale permission.
land sale, okay.
That is a
Here
different
is
issue,
a
Lord.
case, I'm not saying that I have got a big enforceable right. I'm relying on a judgment of division bench of our High Court, my lord, where a lenient view has been taken.
Okay, let the affidavit come then.
Yes.
European Act Learned Standing Council, GMDA.
GMDA law.
GMDA has submitted that an affidavit in opposition has been filed today. Para. Sri Ken Chaudhary Learned Standing Council submits that that copy of the same has been received. Full stop. Please list this case on Monday next along with the affidavit.
Let it be Wednesday, Monday I'm not.
On Wednesday next along with the affidavit.
Lord, that affidavit has been filed in the IA law.
On the IA we are right.
Lord.
Well, I'm very sorry to say, let it be on 5th, my lord.
5th is what?
Friday.
Okay, Mr. Nayak.
Lord, sir, no issue.
On 5th.
Developed.
Earlier
interim order will continue till then.
What is the interim order? Interim order passed earlier to continue till the next date of listing.
Developed.
So that's
My lord, in this case, my lord, I want to delete one, but because it was my submission, page 17, my lord. Paragraph 22.
Page 17.
Yes, last page of IA.
IA.
Yes, my lord. At this stage, Sri Das, Learned Counsel for the petitioner has submitted that his client may be given liberty to negotiate with the private respondents for transfer of the land in accordance with law. So, my lord, I want to, my lord, deletion of that. I am to negotiate with the private respondent for transfer of the land in accordance with law.
You do not want to negotiate?
Yes, madam.
No, his liberty is given.
Subsequently, that line will cover, my lord. Your lordship already observed.
No, liberty, you may not take the liberty.
But a negotiation, in view of the negotiation, other side is going there.
Liberty to, the liberty has been given. You
Yes,
may,
my lord.
You may avail, you may not avail.
Well, so far, my lord, this word, my lord, negotiation.
Liberty to negotiate, you may not take the liberty.
Yes, but client has, my lord, insisting me, my lord, that this part of line.
Where is your IA?
IS 2215.
For deleting that part?
Yes, my lord. Otherwise, your lordship observe, my lord, it is made clear that dismissal of the request shall not be barred for the parties to settle the matter in accordance with law. Your lordship already, but just my submission was wrong.
Yes,
Lordship, regarding the sentence which has already been passed by this honorable court, we have no objection. But regarding they have insert to instead of that sentence, we have objection because
what insert what?
To approach before proper forum.
No. That is not necessary.
That is not insisting. Okay. Third, Sri H. Das, Learned Counsel for the applicant, who by means of this application has prayed for slight modification in the judgment and order dated 17/6/2025. More particularly, certain observations made in paragraph 22.
Yes.
Full stop. It is submitted in that in paragraph 22, this court of the judgment, this court had made an observation that the applicant petitioner would be at liberty to negotiate with the private respondent for transfer of the land in accordance with law. Full stop. He submits that such observation is not required as not required. Pardon? Your name?
S.J. Rajbangsi. For NL.
For respondent number?
5 to 11.
Sri S.J. Rajbangsi, Learned Counsel for the respondent number 5 to 18, submits that he does not have any objection in principle with deletion of the aforesaid observation.
Okay, but to approach before this proper
That
forum,
is
this is
praying.
Not praying.
Also heard Sri N. Goswami, Learned State Council, Para. For any reference, paragraph 22 of the judgment is extracted herein below, paragraph 22, 17. The present application is for deletion of the part of giving liberty to negotiate with the private respondent for transfer of the land in accordance with law. Para. In the considered opinion of this court, the said observation was not a direction but only a liberty granted to the petitioner, which the petitioner may not like to explore. Full stop. Para. In any case, comma, since in the understanding of the petitioner, the same would come into the way of some settlement, comma. This court is of the view that the present prayer for deleting the aforesaid observation be allowed. Full stop. Accordingly, the instant I is allowed by deleting the observations of giving liberty to the petitioner to negotiate with the private respondent for transfer of the land in accordance with law. Let this order be read as a part of the judgment and ordered at 17/6/2025, passed in WPC so and so. I stand disposed of.
Highly obliged. Highly obliged.
May it please, your lordship. Well, this matter which I argued on the last occasion, Melody, they have classified the account as non-performing assets without going by the RBI guidelines. Now, your lordships have filed an interim application, my lord, that your lordship will find. When affidavit was filed, your lordship will find that lordship may kindly see the guidelines of the RBI at page 256. Effectively at two.
You are in the IA.
It's not IA, Melody, it's an affidavit.
No, there is IA 2532.
That's it's there. We are relying on that, but then this
You
is the
want,
latest.
you want to press which application?
This is an affidavit file.
No, in which WPC? 2705?
2705. This is a voluminous one. The lordship got that. Now, your lordship kindly see at page 260. Definition point, that is 2.1. Non-performing assets. An asset including a leased asset becomes non-performing when it ceases to generate income for the bank. Then, my lord, 2.1.2. A non-performing asset is a loan or an advance where interest and or installment of principal remains overdue for a period of more than 90 days in respect of the term loan. This is number one. Number two, the account remains out of order as indicated at paragraph 2.2 below in respect of an overdraft cash credit account. Now we are having cash credit and term loan account. Now what they have done, my lord, within 90 days, 90 days has not been completed. Within that period, my lord, we have given our installment for so many months. Nonetheless, my lord, before 90 days, they have classified it, my lord, non-performing assets. Now, your lordship may kindly see the account which will show that we have been paying in between at page 335. The declaration of non-performing asset is on 31/3/2025. Now the account will show, my lord, your lordship may see the certificate of the chartered accountant. That will be better to look at, my lord, at page 398.
Mr. Datta, what is the issue involved?
Issue is, my lord, in order to classify an account non-performing assets, they will have to show within 90 days, my lord, there was no payment at all, either in the cash credit account or in the term loan account. Now, what they have done.
Your account has been declared as an NPA.
Yes, my lord.
Now you said that 90 days clause was not followed.
Before that, my lord, we have been paying.
That is it, 90 days thing was not, clearance was not followed. Before that,
Exactly.
you were paying, so since the precondition was not followed,
It's not been
they could
followed.
not have declared your
Exactly,
account as
exactly.
NPA. That is your case.
Yes, my lord, that's the case. My lord.
Yes, Mr. Sharma.
Your Lordship, there are two issues that has been given in the writ petition. Number one, that the petitioner company has claimed that they are the MSME, so that their account has to be drawn as per the guidelines of the MSME. So on that day, we have clarified that at page number 260, the limit is of 25 crores, more than 25 crores. Whereas who fall under the guidelines, they have to be within the limit of 25 crores. So number one has been out, your Lordship. And number two,
They are more than 25 crore.
more than 34 crores exposure is there.
No, we are not arguing that.
Not arguing, but it is a claim in the writ petition. That is why I am clarifying the situation. And your
No,
Lordship,
if you do not fulfill the requirement of an MSME, then
the
how do you
very
get the
basis of the writ petition has gone, your Lordship.
No, my lord, what is the position of law is? My lord,
And,
any kind of loan, when we obtain from the bank, they can classify it NPA only if we do not pay 90 days altogether.
Whether you are a MSME or not.
Whether, my lord, any kind of.
Then how do you?
Yes, your Lordship. Now, first claim is there in the writ petition. Now, the second is that we have already issued 13-2 notice and 13-4 notice. So, whatever be their grievance has to be dealt with by the DRT. And the third one is that wrong classification of the NPA. Your Lordship, the very guidelines 4.2.4, your Lordship. 4.24.4 at page number 264 of the affidavit.
My lord, they are not filing their affidavit and verbally saying all that. Let them take the responsibility.
4.2.4
your Lordship.
Accounts with temporary deficiencies.
And more particularly point C, your Lordship.
264.
A, B, and C, your Lordship, three of them has been fault because they have not deposited their balance sheet and they have not renewed their account. And that is regular and ad hoc credit limit need to be reviewed, regularized, not later than 3 months from the due date of ad hoc sanction. And in case of a constraint such as non-availability of financial statement or other data from the borrower, the branch should furnish evidence to show that the renewal review of the credit limits is already on and would be completed soon. In any case, delay beyond 6 months is not considered desirable as general discipline. Hence, an account where a regular or ad hoc credit limit have not been reviewed and renewed within 180 days from the due date or date of ad hoc sanction will be treated as NPA. It is not necessary that the borrower has to be a financially a sound borrower, but he has not completed his criteria, your Lords. They have not reviewed, they are renewed. And your Lordship, in the very writ petition, they have mentioned that there was an internal dispute between the partners.
What is the other one, 2171?
217.
2171 of 2025, Sampat Kumar Taylor.
No,
Yes.
that's a different case. It is not linked with this.
Yes, your Lordship, in
Okay.
that I am coming.
No, that's a different case.
Yes, sir,
In 2171, you have filed your affidavit.
Yes, your Lordship.
That affidavit, will it cover this dispute? No.
No, no.
No, no. In that case, your
I think
Lordship,
you should file your affidavit.
your Lordship, this is a final, so your Lordship, 1 week time may be given. I will file it within 3
File
days.
it within a shortest period of
Yes,
time. Urgency is yours.
Yes, your Lordship.
So that you can, whatever you have just pointed out,
Because
appears to be relevant, you can put it in the affidavit.
Because
Let
none
them
in
say
the
so
point,
that
your
we know
Lordship.
it and we can counter it.
There is nothing in the, your Lordship, in the writ petition, because I am just submitting that by way of the guidelines and by way of the documents produced
You
before.
submit it by way of an affidavit. That will be better
Yes,
for Mr. Datta to answer.
Yes, sir.
Because it is already on record, that is why, your Lordship, I am.
My lord, verbally we can say so many things, but let us say in writing.
No, I am not.
So that you can take
I am
a
not.
responsibility.
I'll file it.
Okay. Hearts free, yes, Datta. That is in a council.
नाम बोलो.
P. Agarwala.
Assisted by Ms. P. Agarwala. Good stuff. Sri M. Sharma, Learned Counsel appearing for the respondent bank, has however submitted that the impugned action has been taken strictly in accordance with law. And no grounds for interference have been able to be made out in the writ petition. Correct? Be that as it may. Be that as it may, the learned counsel prays for and is granted a week's time to file the affidavit in opposition.
Yes, sir.
Please after a week.
Yes,
To
sir.
give a date,
Your lordship, fifth, on fifth maybe. Oh, sorry, fifth, I think holiday. Your lordship. Your lordship, fourth maybe, third maybe. given,
fifth
your
is
lordship.
not a holiday.
Fifth not holiday.
Can
Then
it-
fifth, your lordship.
Can it be on 11th, my lord?
Eight.
Yes.
Eight.
Yes,
My
sir.
lord,
Monday.
8, 9, I'll be at Kolkata, my lord, for personal reason.
On 10th.
Can it be 11? Because on 10th
11th
I'll be available.
Okay, 11th.
Item number
God bless.
49, I am appearing for respondent 2-1.
Item number?
49, first one.
Okay. তো এটা order লিখবো না? শ্রী P. Hazarika appears for RBI.
Yes.
P. Hazarika counsel appears for the RBI in WPC
2705.
2171.
No, money, 2705.
2705. Keshari.
Yes, sir.
God bless.
And what about
My
orders
lord,
in some?
interim order may.
No, Taylor case, what do you
Taylor,
say?
my lord, he resigned from that partnership business.
No, this
That's
is a
a-
separate issue, isn't
Is
it?
it
Separate issue, but your lordship is relating to the same company because this is also going to affect the same matter.
Okay.
Maybe taken up together.
Interim order passed earlier to continue till the next date of meeting.
God bless.
এইটো এখানে লিখিম তো 2705 হ্যাঁ আৰু P. Hazarika appears in হেতু বুলি 2705 তলত লিখিব নালাগে এইটোতে অৰ্ডাৰ পাছ কৰি আছে আৰু টেইলাৰত লিখিব item 2171 লিখিব list along with 25 list along with 2705 টেইলাৰ okay Mr. Tarudar.
My lord, this is a review application and today, my lord, the IA, my lord, has been listed.
IA for?
IA for delay condonation. In fact, there is 114 days delay. And my lord, I have explained, in fact, my lord.
Review in what? Writ petition?
Review in writ petition order. My lord, in fact.
Mr. Tarudar, we have made it very clear. There is no requirement of filing an IA. You can explain the delay
Correct.
in the affidavit itself.
Yes, yes.
But since you have filed, we can issue notice here.
There are all the official respondents, my lord.
Yes, sir.
So, my lord, my friend can take notice. Your lordship can.
We give a short date since you will be representing all the respondents. How many is 114, 117?
My lord.
What are the grounds?
My lord, in fact, what has happened pursuant to your lordship's order, my lord, the coordinate bench of this honorable court
Yes.
had passed an order
Yes.
in identical cases, my lord, on the basis of certain concession of the learned advocate general Assam,
Yes,
my lord
okay.
had passed the order. In fact, an office memorandum came in the way of considering the cases on compassionate appointment, my lord.
Yes.
And thereafter, my lord, the coordinate bench, my lord, has held that the, my lord, cases which are pending on 3/4/25 or which were filed before that date, the government will consider irrespective of the office memorandum. Now, here your lordship has passed the order on, my lord, this was on February, my lord. The order is of 21/2/25. So therefore, my lord, my submission is, my lord, I am covered by the coordinate bench order. And my lord, the office memorandum, my lord, the government has, my lord, made a stand that for the cases, my lord, prior to that date, the office memorandum will not be pressed, my lord. So, my lord, I'm asking that I am similarly situated. So my
Difficult for review. Difficult. You can have it corrected in a writ appeal. We cannot change our views because of a coordinate bench. Had it the coordinate bench before us, we would have definitely given a consideration or followed. Normally we follow.
Yes, my lord, in fact, pursuant to.
If it was not before us, if had it been a larger bench.
Yeah, correct.
then-
I understand, my lord. In fact, what has happened, pursuant to the coordinate bench order, my lord, if I take your lordship's, my lord, only for my satisfaction.
The other judgment is of which date? Coordinate bench.
3/4/25.
Coordinate bench order the common, my lord, that in a batch of writ petition, that was, my lord, passed. It is of, my lord, 3/4/25 pursuant to your lordship's direction, my lord.
And this court judgment.
At 21, my lord, 2/25.
How?
Now, in fact, my lord, what I'm trying to say, that had, my lord, because, my lord, in paragraph, my lord, 15, I have stated, 3 writ petitions were filed on the same date. And this particular writ petition, it came on a prior date, my lord, because it was registered earlier. And the other 2 writ petitions, my lord, that was listed before this honorable court pursuant to the coordinate bench judgment. And in those cases, my lord, the petitioners have got the relief. On the same date, if your lordship kindly come to para 15 of my review application, my lord, that will become very clear.
No, see, our decision was.
I understand, my lord.
Not dependent on the court, government notification.
No.
We had based our decision there on Devrata Tiwari.
No, my lord, lordship is absolutely correct. My lord, in fact, the
And
office.
based on Devrata Tiwari, state government
No.
has given some notifications.
Lordship is correct.
But Devrata Tiwari is a Supreme Court judgment.
No, lordship is correct. My lord, what I'm on, the office memorandum, it has indicated, my lord, that judgment of the Honorable Supreme Court.
Yes.
Now, the coordinate bench, my lord, has, my lord, reiterated that the government, my lord, will not be precluded while considering the cases to take note of, my lord, that Supreme Court judgment. That has been, my lord, clarified, because Supreme Court judgment cannot be diluted, man. That is there, my lord. But the office memorandum, which has come in the way of consideration, that has been waived, my lord. Only I'm on that, my lord. But similar, exactly similar. I'm asking for.
Suppose if the office memorandum is not there,
my lord,
in view of Devrata Tiwari, can it be considered?
No, that is a different aspect. What I'm on the.
We have considered Devrata Tiwari.
No, because your lordship will kindly see the office memorandum, my lord, the last para, page 52. It refers to, my lord, Devobrata Tiwari.
Yes. No, we are not the office memorandum.
My lord.
We are on the law laid down by the Honorable Supreme Court.
Yes.
Based on that law, the state government has framed an office memorandum. We are not on that.
Yes.
Whether there is an office memorandum or not, the law laid down by the Supreme Court has.
That is correct, my lord. That is one, my lord, one of the perspective is there, always there, my lord. I concede to that, my lord. But despite such, my lord.
Not a case for you. We condone the delay, we dismiss the review.
I leave it to your lordship, my lord. But look, my lord, my submission is I stand on a similar footing, my lord. All the other, my lord, petitioners, my lord, they have got the relief, my lord. On the ground of parity, my lord. I'm only asking for that.
The parity you can seek in the appellate court.
That is, lordship is correct.
If it was a fresh consideration, matter would have been different. Hey, it is some Third, Sri S.K. Talukdar, learned counsel for the applicant who by means of this application has sought for condonation of delay of 117 days in filing the review petition. The review petition has been filed against an order dated 21/2/2025 passed in WPC 941 of 2025. The learned counsel, Sri Talukdar, has drawn the attention of this court to the averments made in paragraph 4 of the petition and has submitted that under those conditions, the delay has occasion in which there is no delay, there is no negligence or laches. Sri N. Goswami, learned state council, has not seriously objected to the aspect of condonation of delays. In a writ proceeding, there is no strict, the Limitation Act 1963 Part C is not applicable. Full stop. At the same time, the powers being equitable in nature, the aspect of laches will always be there, and therefore, therefore, this present application has been filed. Full stop. Upon considering the grounds set forth to justify the delay, this court is of the opinion that the delay in referring the review is liable to be condoned, which is accordingly done. I stands allowed.
So can you see the order of page 72, page 72?
No, review we are dismissing.
Look, it is clear that it shall only apply to the cases that are pending before this court as on 3-4. This observation is also dear. Page 7.
And in the review, right? Part 3 SK Talukdar, learned counsel for the applicant
72.
who by means of this application has sought for review of the order dated 21/2/2025 passed in WPC 941 of 2025. Full stop. The learned counsel, Sri Talukdar, has submitted that after passing of this judgment, a coordinate bench has passed a judgment dated 3/4/2025, whereby there is an observation for consideration of the cases of those writ petitioners, irrespective of the office memorandum of the government dated 18/9/2024. Para. 3. And Goswami Learned State Council has however submitted that no grounds for review has been made out. Para. The principles governing review are well settled in the case of Para. In the instant case, the ground of review is based upon a judgment of a coordinate bench dated 3/4/2025. Full stop. The observation made by the coordinate bench is of a subsequent date and cannot be a ground for review. Full stop. In any case, the judgment dated 21/2/2025, of which review has been sought for, is based on the decision of the Honorable Supreme Court in the case of State of West Bengal versus Debabrata Tiwari, reported in so-and-so. Full stop. Though it appears that the state government has formulated an office memorandum dated 18/9/2024 based on the aforesaid judgment, the application of the principles laid down by the Honorable Supreme Court in the aforesaid case of the Debabrata Tiwari is of relevance. Full stop. Para. In the considered opinion of this court, the present grounds may not be sufficient to invoke the review's jurisdiction. Accordingly, the application is dismissed.
Obligation.
May I please, your lordship?
Yes.
Lordship. In this case, I was filed for lordship correction of post title. Correction of yes,
Whom do you want to implead, madam?
Lordship.
Whom do you want to implead?
Lordship for.
Respondent number 9,
Respondent
lordship.
number 9, lordship.
9.
This, yes, lordship, and 1 also.
Huh?
1 and 9.
1 and 9.
Yes, lordship. 1, the commissioner and secretary to the GovTA person on site and rural development. This for 46. It should be the state of Assam represented by the commissioner and secretary.
Lordship, in PNID, commissioner and secretary both are two different posts. Commissioner would be different and the secretary would be different.
Not make any difference. Their department is there. One is okay, one is already there, the department is there.
Yes, Lordship.
Then whom do you want to include?
Lordship, especially 9, Lordship.
9.
Yes, Lordship.
Lordship, by earlier order, respondent number 9 was likely to be included by name.
By name, yes.
Earlier, who was respondent number 9?
Secretary. Namarpara Gaon Panchayat.
You can make the party by name separately. Now, if the incumbent, he is no longer the secretary, what will happen to the cause of action? Let the secretary be there. You want to implement the person also, he will be another respondent. You need to structure your applications properly, madam. Third, what is your name?
A. Ahmed, Lordship.
K. Ahmed. Come to the now. Heard Miss A. Ahmed, Miss A. Ahmed, learned counsel for the applicant writ petition of who by means of this application Yes, madam, what is 152 of the CPC?
Lordship.
What is your cost title? 152 of the CPC.
Oh, Lordship. It may be mistake, typical mistake. Under section 153 should be, Lordship.
It should be
151, 153. 3. 153.
be careful in writing sections and provisions of law. Who has filed this application for correction of cost title in the connected writ petition WPC 2066 of 2025. It is submitted that while presenting the writ petition, the respondent numbers 1 and 9 were described in the following manner. Number 1, page 2, 1, number 9 and it is 9 and hold on. The learned counsel has submitted that the said respondent numbers 1 and 9 are may be corrected in the following manner. 1, it will have 1, there was some 9, what was your name? Sorry, we talked.
A.K. Ghosh on behalf of Mr.
A.K. Ghosh, on behalf of Datta.
Yes.
Sri A.K. Ghosh, learned counsel appearing on instruction of Sri S. Datta, standing counsel PNRD, has however submitted that in the department, the commissioner and secretary are two different posts. Be that as it may, since the department as such would be represented, the corrections sought for in this application are allowed. The learned counsel for the petitioner is accordingly required to file amended cost title in the writ petition within a period of a week from today. Full stop. Then we have to issue notice to respond number 9.
Yes, Lord.
You get it. Let the writ petition be listed after filing of amended cost title. Highest and disposed of.
53.
Wait. My lord, I'm appearing for the private respondent number 5, my lord. I seek 2 weeks time to file my affidavit.
What is the matter, my question?
My lord, here, my lord, there is a retail outlet, my lord, which happened to be the retail outlet of the grandfather of the petitioner and the respondent number 5. Now, that after the death of the retail outlet, no
Not
reconstitution.
death of the retailer, death of the grandfather.
Grandfather.
Not the retail outlet is not died.
After the death of the grandfather, my lord, the firm was never reconstituted, my lord. Initially, my lord, the IOCL stopped the retail outlet on account of non-reconciliation.
This matter we have taken up before.
Yes.
Same
yes.
matter.
Yes, same matter.
Some 3-4 years back.
3-4 years, sir. Thereafter, my lord,
There was a writ petition, there was a writ appeal, my lord.
and in fact, the division bench.
Tinsukia.
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 Yes, sir.
Yes, yes.
In fact, my lord, division bench made a direction that within 6 months, all the family members should reconstitute, take an opportunity for reconstitution, and if not done, till that 6 months and under the holiday scheme, the respondent number 5 was allowed to
Okay,
run.
let Mr. Nath file the affidavit then.
Well,
Heard Sri B. Kaushik, learned counsel for the petitioner. Also heard Sri M. K. Chaudhary, done a senior counsel for the IOC.
1 to 4.
IOC.
My lord.
Whereas Sri D. Nath has appeared for the DM Nath. Has appeared for the respondent number 5. Full stop. You have filed affidavit, Mr. Taran.
No, my lord.
Will you like to file affidavit?
in fact, IOCL affidavit is more important. Like, we are seeking a direction against
Both
IOCL.
Sri Chaudhary as well as Sri Nath, Senate Council, pray for and are granted some 3 weeks time?
3 weeks.
3 weeks time to file affidavit in opposition. List after 3 weeks.
Public.
My lord, in this case, precisely the issue was whether the respondent, my lord, 9 and 10 were, my lord, subjected to disqualification, my lord, to be elected as, my lord, directors. And this honorable court, my lord, while issuing the notice on 39/24, was pleased to direct, my lord, the register to file an affidavit regarding, my lord, in respect of this particular issue. Now, my lord, the register, my lord, thought it proper to, my lord, have a view from the Reserve Bank. And therefore, my lord, when I apprised this honorable court, the Reserve Bank was, my lord, implicated as one of the respondents. Now the view has been forwarded. My lord, my learned friend has, my lord, apprised the honorable court that the view, my lord, of the Reserve Bank has been, my lord, forwarded to the register. Now there is no impediment, my lord, in taking a decision. So, my lord, this case can be closed, my lord. And thereafter, my lord, whatever decision is taken, if the, my lord, petitioners are, my lord, aggrieved, then, my lord, a fresh cause of action will be there, my lord.
Lordship, precisely the issue which the registrar is now seeking to decide, that issue is pending before your lordship. If your lordship has the order at 39/2024, the department was directed to file an affidavit just on the factual aspect as to whether these private respondent number 9 and 10, they are disqualified under provisions of section 40. That direction was also reiterated on 23/7/2024. Now, instead of filing the affidavit, your lordship, if the matter is relegated back to them, your lordship, we are challenging their decision, your lordship. They have already they have already approved the election appointment of the private respondents as the directors, your lordship.
That decision is already out.
That decision is already out. So unless that decision is set aside, or they say that we are not going to, we are going to revoke that decision, there cannot be any question of your lordship taking a fresh call. That is what I have challenged in the petition. And twice this honorable court has directed them to file their affidavits.
My lord, for...
Since you have taken their views, you file your affidavit, will decide the case.
Yes, my lord, there is no impediment in filing. I'll file it, my lord. But here, the issue, my lord, was with regard to their election as directors. So pursuant to their election, my lord, no view has been expressed by the registrar. And registrar view is not under challenge, my lord, in the writ petition. So I disagree with my learned friend in that aspect, my lord. I will
Mr.
file an
Pathak, how do you
affidavit.
say that registrar?
Yes, because
Registrar has expressed his opinion.
yes, your lordship, there was an, after the election, results were announced. The AGM, your lordship, there was the minutes of the AGM, your lordship, were sent to the registrar, and registrar.
Mr. Pathak, the best way is to have this petition pending, let the registrar take a call. Raise the registrar, if it is in your favor, you
Yes.
withdraw the petition, it
Exactly.
will be pending. If it's against
Yes.
you, we'll be deciding.
Very well.
Correct.
Then let them at least bring that decision on record
Yes,
by
yes,
way of
yes,
the
yes,
affidavit.
yes, yes, yes.
Very well.
Lord,
So
we
that-
will only fix a outer limit that within this
Yes.
particular 10 days,
Sir,
15 days.
KP Pathak, learned counsel for the petitioners. There are also heard through SK Talukdar, then standing counsel, Cooperation Department, as well as P. Hazarika, learned counsel for the Reserve Bank of India. Madam, you are for somebody? 4, 5, 6, and 7.
Industrial bank.
Madam, your name? Asdas, Miss Asdas, semicolon, for responsibles, 5, 6, and 7 packet, Industrial Cooperative Bank. And Mr. Borthakur? What is it? 12, 12, 13, 14, and 16. Huh? As Borthakur. Fair. Sri Talukdar, the learned standing council has submitted that after filing of this writ petition, comma, the RBI was subsequently implemented.
Yes.
And implemented, which has conveyed its view to the Cooperation Department
On 9th of June.
on 9/6/2025. Full stop.
But in respect of that issue, with regard to disqualification of 9 and 10, respondent 9 and 10.
They said view is on the aspect of the disqualification of the respondent numbers
9 and 10.
9 and 10.
Mal.
Puts the para. 3. This court is of the opinion that while the writ petition be kept pending, comma, the department be directed to take a decision, final decision on the issue before it, and bring the same to the, and place the same on record. Full stop. Let such decision be taken within an outer limit of
15 days.
15 days. 15 days. Full stop. Depending on the decision which may be taken, comma, this court would pass further orders in this writ petition.
Very
full stop.
My lord will indicate a registrar, my lord. Registrar will pass the order.
Registrar. Decision by the registrar of Cooperative Society.
Then the other
It will be subject to further orders in this.
Yes, yes. Yes. Next. What is IA for?
And we have written to directors, it may be closed, madam.
IA may be closed.
Yes, sir.
IA for what?
IA for appointment of administrator from RBI, madam.
Lordship, in the main petition, the interim order has to be extended.
Interim order passed till it stayed extended till the next date of listing. In IA, you write IA 1757, huh? Third, Sri S. Borthakur, learned counsel for the applicants who by means of this application had made the following prayer. Put stop. Sri Borthakur, the learned counsel, a prayer ko put kar dijiye, has however submitted that the applicants have since resigned from the post of directorship. Put stop. Accordingly, there is no requirement to press the present application. Put stop. The application accordingly stands dismissed. This will be in the IA.
My lordship, please.
Just a minute. Yes, Mr. Doctor.
Yes, my lord. My lord, kindly have a look at 5/12/2024 order.
5/12.
2024. My lord. Yes, madam.
Yes.
Regarding the reconstruction.
So, in fact, we have filed a revision application in regard of the land ceiling case. So that record required to be reconstructed. But
They have,
but
Madam has given placed some written instructions
In
that,
this case, Lordship, District Commissioner Kasar has expressed inability to reconstruct the
yes.
ceiling case record.
So what
These
I
are old
propose, my lord-
cases, they have said they have expressed some.
Yes, so what I propose, my lord, subject to the approval by this honorable court.
Lordship,
That-
Department 6 signed to the Lordship permission from this honorable court to dispose the pending revision petition dated 12/4/1999 on the basis of the available materials and field and ground situations, Lordship.
Revision is before whom?
Before the secretary, madam. What happened?
Revenue and Disaster Management.
What
Department,
happened? We had purchased the tea garden, 3,181 acres. We had purchased the tea garden. Thereafter, we came to know in 1980, mutated. Then thereafter, we came to know that there was a land ceiling of 367 acres, 2 cutters something. So therefore, we have referred an application before the Secretary, Revenue Department for reconsideration of the.
After we had purchased the
Yeah,
property.
after the purchase of, in 1999, we have preferred the revision application. Okay. So thereafter, the report was called for by the Revenue Secretary. The Deputy Commissioner says that already 67 acres have been allotted to some small tea growers. And the
of the ceiling land.
of the ceiling that acquired land. Now, the 300 acres is a big chunk of the land that is situated within the compact area of the tea estate.
Your tea estate.
Yes. And it is only suitable for the plantation. That is the report of the Deputy Commissioner. And that report has been sent to the government. And we say that please reallot the land since it is our planted areas, is involving the employment, etc., etc. But that matter is pending. Since the matter is pending, in meanwhile, we have received a caveat from a respondent number 6 here, private respondent, wherein they said, addressed to us, that a proposal was approved in a land advisory committee of relating to 284 acres of land. This subject matter of this land ceiling. So therefore, thereafter we are before this honorable court challenging that proposal as well as that to settle our entire matter. The honorable court has to take a view that since the revision application is pending, so therefore it has to be disposed of. But that record was called for, that was not available, or that was missing. Therefore, what I proposed,
Madam, we think that you can dispose of the pending revision, whatever materials are there.
Yes,
And
Lordship.
that will obviously be subject to the.
what I propose, my lord, subject to the approval, what I propose, the status quo already passed in 2017, we are filing this rate application. The status quo be maintained, and meanwhile, they may dispose this revision application. And that's by that the matter may be closed.
And so for your, this thing is there. What is your cause of action in this petition?
Our cause of action, in fact, arose after that allotment. When we came to know in 2000.
But don't you think that your revision before the appropriate authority is independent of the proposal, which is the subject matter of challenge? If we close this, you will be precluded from making a challenge of the proposal to allow 280 bighas from whom you have received the caveat.
These 284 acres, my lord, of 9 kattha, 2 chatta, that is a subject matter of that 300 acres of the land ceiling cases. And that we are already on before the revenue authority under subsection 6 of section 6, land on Act 19 Lordship is aware. Now, what I propose, my lord, if it is suitable, that let the matter be closed with a direction to maintain the status quo so far this land is concerned, and the matter may be disposed of by the secretary, my lord.
Status.
And liberty to be given, if anything adverse, then we may challenge it before this honorable court.
Only thing, Lordship, in our affidavit, Lordship, it has been said that Lordship, after this land has allotted to respondent number 5, after if status quo has been given, Lordship.
In this.
Has it been allotted to respondent of?
Yes, as per our affidavit, Lordship, it was allotted.
My instruction. Lordship.
Challenge, my lord. It's allotted to a Keshav Sampark Samiti, which is a non-entity with having no relation with the special cultivation.
Lordship, in this, I have received instruction that some another land, another proposal for allotment of land measuring 30 biga in the name of case of some Samrak Samiti Silchar, Lordship, as proposal, Lordship.
There is no
Lordship, may
related-
peruse my instruction, Lordship. And annex are 2, Lordship.
We submitted the proposal, my lord, page 44.
Now see, Mr. Doctor, the cause of action in this petition
My lord.
is against the proposal which perhaps Mr. Roy has said that it has already been allotted.
As per
Yes.
our affidavit.
Now, suppose your revision is allowed in your favor. This particular order of allotment has to be looked into or maybe set aside by some competent authority.
Yes, sir.
In the revision, this is not the subject matter.
No.
So by
Absolutely.
closing, you are twice you have said this will be closed. If you close this, you lose your revenue to challenge this.
My lord. That aspect is there.
There is no problem in directing completion of your revision and passing appropriate orders. If you are aggrieved, you can challenge. If you are not aggrieved, then you can take support of that in your petition, in this present petition. But if you close this, I'm just leaving.
Yes,
If
yes,
you
yes.
think that the revenue authorities can also look to consolidate this matter of allotment to fresh party while considering your revision by giving them a hearing, is they represented? Are they represented?
No,
They are not
they're definitely not. They are coming in this latest development.
No, here in this writ petition, whoever.
Yes, they represent, but they did not after receiving the notice. Mr. Mr. Bhaumik was there, Mr. New Council, but thereafter they did not appear. They have no interest as far as my lord, because that chunk of land is in the Tila.
But Mr. Roy, from where are you submitting that they have been allotted the land?
Lordship, page 50 of my affidavit, Lordship.
50. What is it there? What have you stated there?
Lordship, it starts from page 49, Lordship, para 4.
But I'm just interpreting. This is only proposal, my lord. What happened in the land advisory committee? Ultimately, the settlement was done by the government.
Mr. Roy, in one sense, he is correct. He may be correct. If the revision is decided in his favor, then this proposal will not fructify in anything.
Yes, my lord.
It is still in the realm of a proposal. Now, if the land is reverted back to you, then proposal goes.
And the DC's report, my lord, the DC Deputy Commissioner report we have annexed here in page 28. Clearly says so.
Okay, we'll do that then.
Lordship.
Third. 3. As Abir Atta, Learned Senior Counsel for the petitioner assisted by what is your name?
J. Das.
J. Das. Learned Counsel. Also heard. 3. S. Roy.
3 and
Learned
4.
State Counsel.
3 and 4.
As well as Miss J. Hazarika, Learned Standing Counsel, Revenue Department. Full stop. The respondent number 5, which has been served, has chosen not to appear and contest the writ petition. Is there an order of service?
In fact, they will appear, my lord. Their name is appearing in the cause list.
None appears. No, don't write that. Last limit. None appears for the respondent number 5, in spite of the names of the council being reflected in the cause list. Karen? As per the, please have your seat.
Yes.
As per the facts projected, the petitioner had acquired ownership of a tea estate in the name and style Binod, B for Bombay, Binod Nagar Tea Estate, consisting of land measuring 3181 bigha, 14 katha, 11 chatak at Dwarband, Kachar, Dwarband in the district of Kachar on 28/1 to 1980. Whereafter, mutation was also granted in favor of the petitioner on 8/2/1980. Full stop. However, due to financial liabilities, the petitioner could not operate the tea estate, and consequently, there was lockout in the year 1988. Full stop. The petitioner had later revived the tea estate by regularizing the wages of the staff and the laborers. Full stop. In January 1999, the petitioner came to know that land measuring 367 bigha, 9 katha, 2 chatak of the tea estate has been declared as ceiling surplus by the collector, Kachar, wide order dated 20/1/1975 in land ceiling number 2 of 1973-74. On receiving such knowledge, on coming to know of such on coming to know about the aforesaid aspect, the petitioner had preferred a revision in November 1999 for exempting the aforesaid land from ceiling surplus or to reallot the same in favor of the petitioner. Consequently, a field survey was conducted by the in terms of a communication dated 22/4/2000 of the Deputy Commissioner Kachar. Full stop. It was informed that 300 bighas of land is situated in a compact area of Binod Nagar tea estate of the petitioner, and there was a suggestion that it would be suitable for special cultivation, and accordingly, there was a recommendation for disposal of the revision petition. Full stop. Though sufficient time had elapsed, there was no decision taken in the revision petition, and in the meantime, the petitioner came to learn about a proposal via a letter dated 25/8/2017 to settle an area of 284 bigha, 9 katha, 2 chatak in favor of the respondent number 5. Full stop. Accordingly, the writ petition was filed. Full stop. Parent Sri Datta, the learned senior counsel, has submitted that when the revision of the petitioner was pending consideration before the appropriate authority, the proposal to make allotment in favor of the respondent number 5 would preempt the rights of the petitioner. Full stop. He has also submitted that while acquiring the ownership of the land in question, the petitioners were not aware of the ceiling proceeding, which was of the year 1975, and all these aspects have been highlighted in the revision filed by the petitioner. Para? Ms. G. Hazarika, the learned Standing Council, Revenue Department has, however, placed before this court written instructions dated 16/8/2025, along with the relevant documents. Full stop. She has submitted that the records pertaining to filing of the revision, which was in the year 1999, could not be traced out and traced out. Could not be wholly, Could not be wholly traced out or what? And some reconstructions have been done. Full stop. It is accordingly prayed that though reconstruction of the ceiling cases was not wholly possible due to insufficiency of required records pertaining to the years 1970s, the department may be allowed to dispose the pending revision on the basis of the available materials and field ground situation. Full stop. The materials have also been enumerated in the written instructions dated 16/8/2025. Sri Dr. The learned senior counsel has submitted that in view of the aforesaid facts and circumstances, he would not be opposed to a decision, to a direction to decide and dispose of the revision petition preferred by the petitioner. Full stop. Within a specified time. Full stop. He, however, has submitted that the order of status quo,
Yes, sir.
which was passed
On
in this
13/7.
petition, be kept pending. Full stop. Be kept operative. After considering the submissions advanced by the learned counsel for the parties, this court, upon perusal of the written instructions and the documents enclosed, which have been placed on record, is of the opinion that the equities would be balanced if the department is directed to dispose of the pending revision petition filed on 12/4/1999 based on the materials which are presently available. Full stop.
Then also field verification.
This court has noticed that amongst the available materials, the following materials have been highlighted, which are as follows. Is field verification also already there? But 1, 2, 3, 1, 2, 3. Yeah. Written instruction 1, 2, 3. Well, accordingly, the instant writ petition is closed by directing the department to dispose of the revision petition on the in terms of the in the manner indicated above, expeditiously and preferably within an outer limit of 2 months.
3 months.
3 months.
3 months from today. Full stop. Full stop. To balance the equities, it is further provided that the order of status quo, which was passed in this writ petition, shall remain operative till the disposal of the revision petition.
Well,
it is also clarified that the aggrieved party, that any party which may be aggrieved by the decision taken in the revision petition would be entitled to approach the appropriate forum.
Nice. Grateful.
The written instructions placed before this court are made part of the records. Madam, you have a copy?
Yes, Lordship. Prepare.
55.
Replay.
This matter was heard on the last occasion, my lord, to some extent, my lord.
By the last order, your lordship will see, my lord,
State Bank and the RBI will directed to obtain instruction.
Yes, whether it is, that senior
Yes,
citizen.
My lord.
Oh, fraud, bank fraud.
Bank fraud.
Yes, yes.
But from RBI it is awaited, madam. And Mr. Das is also not present today as SBI.
Who's Das? Okay, Das.
Yes.
Okay, we had, I think, directed him to obtain instructions
My-
whether the accounts are insured.
Insured.
Okay.
Matter will be taken up after.
My lord, that is
in some
actually
other
for the
day.
liquidation part, but he let him take instruction when the bank goes, my lord, bankrupt. In that case, my lord, if that minimum insurance amount is there, my lord.
No, the accounts are also insured.
My lord.
For that, the fees are paid by the bank.
My lord. And unfortunately, my lord, the petitioner is also expired. One of the petitioner already expired recently. Today, 10 days have passed, my lord. So,
That OTP matter.
yes, yes. Well, two things have happened here, Lord, that
One part you have been paid.
one part
And
of
one
the-
part they said that they did not get the information.
Yes.
After
I
launching
think
of the
SBI will hear SBI more than Mr. Hazarika.
Yes, ma'am.
Yes.
Mr. Das would probably
Well,
have.
he, I'm told that he has some personal.
Okay, when can we have this?
Minutes. On the on 11th of
4th
No?
September.
4th of
In a hearing day, 4th or 11th. In it.
4th, my lord.
Fourth. Okay, we'll try on 4th.
Malay.
Fourth, okay.
Lord,
Those
can
three H. Gupta Learned Counsel for the petitioners and Sri P. Hazarika Learned Counsel for the RBI are present, comma. There is no representation from the State Bank of India. Sri Hazarika, the Learned Counsel, has submitted that the Learned Counsel for the SBI has got some personal difficulty. Correct? In view of the above, matter is consideration of this matter is deferred till 4th of September. You are appearing, Mr.
Yes, respondent 6.
SS Roy for state respondent. State respondent.
Lordship, Deputy Commissioner Crime.
My lord, may I pray to be kept as a part heard, my lord, since my lord has heard it on the last occasion to some extent. My lord.